Yes, I'm sure that no one here is disappointed that you won't have to come and appear before these three handsome men up here on the podium. Let's take appearances for the record, and you can tell us the witnesses. We have this, but I want to put it on the record. The witnesses that you tend to proffer for summary and cross-examination, and have there's a couple of folks here that I don't recognize, so I assume they're all with you. So no, not so. Oh, okay, sure. Well, that makes perfect sense. Yeah. All right, so let's start with Mr. Moskin, and let's have you.
Thank you, Mr. Chair. So Matt Moskin and my colleague Cameron Sabin on behalf of Rocky Mountain Power. I'll also note that Mr. Joe Dallas, who has appeared before the commission previously, is here, and with the chair's permission, will substitute during the day, likely at a lunch break for me at this chair as we proceed throughout the proceedings.
There's only so much you can take, right?
Right.
Okay.
To answer the question about witnesses and order, the company intends to present Ms. Stewart and Mr. Josh Jones as our first witnesses, and I'll be leading those two through their testimony. And then we'll turn to Mr. Barrett and Ms. McCoy, and Mr. Sabin will handle the direct of those witnesses.
Okay, great. Thank you very much. All right, let's go to the Division of Public Utility. I see you've switched chairs, so this probably indicates a change in who's conducting the examination today. Go ahead.
It does. My name is Patricia E. Schmid. With me as counsel is Patrick Griecu. We both are Assistant Attorney Generals representing the Division of Public Utilities. The division will be offering one witness today. His name is Jonathan Lee. Thank you.
All right, let's go to Mr. Moore, or is this going to be Mr. Snar?
We'll do an interesting tag team, but mostly I'll be here taking care of some of the work to be done today on behalf of the Office of Consumer Services. We'll be presenting as witnesses at the appropriate time Bela Vastag, Dennis Stevens, and Paul Alvarez.
Is that going to be the order you're going to present them in? I have Alvarez and then Stevens.
I think we're going to go with Stevens first and then Alvarez.
Okay, all right, that's fine, no problem. It's nice to have you back, Mr. Snar.
Thank you.
And welcome again, Mr. Moore. All right, so let's talk to the folks from the forestry. Is it department or division?
It's the Division of Forestry, Fire and State Lands.
Forestry, yeah.
But obviously that's quite the mouthful, so forestry often works.
I'll just call you the forestry folks.
I think we can work with that. But I'm Assistant Attorney General Carter Moore on behalf of Forestry, Fire and State Lands. Counsel of Record, Mr. Mike Bagley, will be here in hopefully about an hour to relieve me, but he had prior commitments, and the main attorney is unfortunately sick with pneumonia today.
Oh, my heavens. Well, I'm sorry to hear that.
But we've been avoiding her plenty.
I hope just in the last couple of days. All right, so you're going to be here, but probably who's going to be conducting the exam? Are you presenting Mr. Melton?
Forestry is presenting Mr. Mike Melton, who's sitting next to me, but Assistant Attorney General Mike Bagley will probably be the one.
It Bagley?
Yes.
Bagley, okay. All right, thank you very much. And that will be, your schedule, Mr. Melton, to be the last witness tomorrow is what we have. So you can back clean up for everybody, so.
Sounds great to me.
Okay, great. All right, Mr. Russell.
Philip Russell with the Utah Association of Energy Users. Our witness will be Kevin Higgins.
Okay. Ms. Hayes.
Good morning. Sophie Hayes with Western Resource Advocates. We have no witness for this last leg of the proceeding, but I am here and notice that Dr. Mitchell is also here, so I'm happy to function as presenter for Utah Clean Energy's witness today.
Yes, okay. Well, and I've read Dr. Mitchell's testimony, so I know he'll be, I think you're scheduled to be the second to last witness tomorrow. So that's the plan. Okay, thank you, Ms. Hayes and Dr. Mitchell. It's nice to have you with us and others that are here. Okay, so the first order of business is to talk about post-hearing briefs on Phase 3. Mr. Moskin raised that with, there was, I think most of the lawyers were represented in a little sidebar conversation we had on Friday, and so I thought about this over the weekend, and I asked our staff to see if there was anything in the filings as far as our orders where we talked about post-hearing briefs for Phase 3, and I couldn't find anything. But I seem to recall I said something in one of the hearings that we would consider allowing that, or we would allow it. And so I like to be a man of my word. And so so here's what we're going to allow. We're going to allow you to file, I could have, if I thought about it more, I could have told you on Friday. But this is going to be in a fairly compressed time schedule. I don't know, it's up to you whether you want to try to get a transcript or not, but here's what we're going to do. We're going to allow you to file, anybody who would like to file a post-hearing brief on Phase 3 issues, both the legal issues, may do so. And they will be due, I wanted to give you another weekend since I didn't give you the weekend if I had told you on Friday. So, but I also want us to be able to get to them. So this is a little unusual, but I want the briefs, if you are planning on filing them, to be filed no later than 10 a.m. on Monday, April 7th. Okay? And I suspect you could grouse about this a little bit, but we're going to limit them to 25 pages, which is consistent with state court on motions for summary judgment, 25 pages. If you are, we'll get an order out on this. If the parties that are not here that have participated in the excess liability insurance issues, they can file 15 pages. If you're going to file on both, I say 12 and a half, but that doesn't make any sense. So just 25 pages, standard typeface, standard margins, that type of stuff. But here's what I would say. I hope this gives some guidance. I wouldn't engage in a long recitation of procedural or factual things. I think we're all pretty clear on that, or a long recitation of facts. I would marshal the facts in connection with your legal arguments that you plan to present, okay? And you obviously are very experienced, all of you, in doing that. So give us the facts that you think support the legal positions that you want us to consider. That will still give us really 15, well, it includes the day the order comes out. If you get them in by 10 a.m. on Monday, and I'll just say, hey, there's no reason you can't get them in on Friday if they're done. Get them in whenever you can, but that's what the plan is. All right, so I'll listen to any murmuring if you have any, but that's the plan. Anybody want to suggest or murmur?
No
I would.
murmuring.
Go ahead.
Okay, go ahead.
Chair,
Yes.
Vince, I apologize for interrupting. While they murmur, I brought the wrong binder. I'll be right back in 30 seconds. I'm sure I,
You're going to miss some really important stuff here as the murmuring goes on. No, I mean, I'm being serious, though. Just let me know if what your concerns are on it. Ms. Schmidt, you have some concerns.
I do. Would the commission please consider ordering expedited transcripts? I believe that the Division of Public Utilities cannot order that itself. And I believe that if some parties have transcripts and others do not, the parties lacking them will be disadvantaged.
I think that's a legitimate point that you're raising, and so we would bear the cost of the expedited transcripts. I suspect Rocky Mountain Power would order them if we didn't, and you might not have the resources to do it. I understand that. So I don't know what, there's two different court reporters here. That may help, because you've got, first part and second part, but we'll order and Melissa can help us with that, but we'll order expedited transcripts of the two phases of the hearings. I don't know what that expedited means. It still's gonna take several days, I suspect, to do that, but we'll pick up the cost of that and order those.
Thank you.
Okay? All right, that's a very good point. What else as far as other things we need to consider? Was facetious about the murmuring, but if there's other things we need to consider, please tell me. Anybody else?
Just a quick point of clarification. Are the briefs intended to be limited to legal argument? I mean, obviously, we're going to have factual support for those legal arguments, but are you asking us to limit the arguing part of it to the legal
Yes,
points? Okay.
Yes, I thought maybe I needed to be more precise, clear on that, but yes, that's what we intend. And marshal your evidence to support that. If you want to cite to the transcripts or to the pre-file testimony, you obviously have facts, but I would put them in your legal arguments. I don't think it's going to be that helpful to have a long recitation of fact issue. I would just jump into the legal arguments you want to make and give us your best shot on the facts and support it.
Thank you. I thought I had heard you say that. I just wanted to make sure that I heard it correctly.
Yeah, you did. Okay, anything else? Okay. Let's begin. Mr. Moskin, you can call your first witness.
Thank you. The company calls Ms. Joelle Stewart.
Ms. Stewart, welcome. Hopefully it's the last time you have to appear for a while before us. Do you solemnly swear that testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated. Mr. Moskin.
Thank you. Good morning, Ms. Stewart. Would you please state your name, spelling your last name, and identify your position with the company?
My name is Joelle Stewart. I'm the Senior Vice President of Regulation for Pacific Corp. And my name is spelled JoelleSteward.
Thank you. Now, in this proceeding, you have already had admitted into evidence in front of the commission Phase 1 direct, amended direct, and rebuttal testimony. I want to draw your attention to testimony that you filed in this Phase 3 and specifically on wildfire mitigation. I show that you have filed both what is identified as Phase 3 rebuttal and Phase 3 surrebuttal testimony on WMP issues. Is that correct?
Yes.
And are you aware of any errors or corrections that need to be made in that testimony?
No.
So if I were to ask you the questions set forth, would your answers be the same as included in your pre-file testimony?
Yes.
The company moves for the admission of the Phase 3 rebuttal and surrebuttal testimony of Ms. Stewart as it pertains to the WMP issues in this docket.
Thank you. Is there any objection to the admission of the Phase 3 rebuttal and surrebuttal testimony of Ms. Stewart? Seeing none, we will admit them.
Thank you. Ms. Stewart, have you had an opportunity to prepare a summary of your wildfire mitigation plan testimony?
Yes.
Would you please share that?
Yes. Thank you. And good morning again, Chair Fenn, Commissioner Clark, Commissioner Harvey. In this case, Rocky Mountain Power seeks commission approval of several items related to its wildfire mitigation plans. First, the company requests approval of its 2023 wildfire mitigation plan. Second, the company requests the commission approve the cost associated with the plan for the 2025 test year that will set the amount in base rates for purposes of tracking and truing up costs in the wildfire mitigation balancing account. Third, the company requests recovery of $22 million for deferred costs over 12 months through Schedule 97 associated with wildfire mitigation plan activities that occurred in 2021 through 2023. The specific amounts and associated revenue requirement calculations are in the testimony of Shelley McCoy. Finally, the company recommends the commission initiate a new proceeding to facilitate a collaborative approach to quantitative evaluation of potential costs and risks for consideration in future wildfire mitigation plans. The intervening parties in this case consistently recommend the commission not approve the 2023 WMP, claiming it does not meet the statutory requirement to demonstrate the risks and costs are balanced. However, the consistency ends there. The parties present wide ranges of recommendations for the appropriate way to conduct a quantitative evaluation of the plan. When the company prepared its 2023 plan, it adhered to the requirements of statute and commission rule, as well as past commission orders that were available at the time. The Wildfire Planning and Cost Recovery Act enumerates the elements that must be included in a wildfire mitigation plan. The independent evaluator and the Utah Division of Forestry, Fire, and State Lands have stated that the plan meets all of the required elements, and no party has argued otherwise. The company does not dispute that the statutory language also requires the commission to approve a plan that appropriately balances the costs of implementing the plan to the risk of potential wildland fire. As discussed in the testimony of company witness Josh Jones, who you will hear from later today, the company believes that the 2023 plan provides substantial evidence for which the commission can make a finding that the costs and risks included in the plan are balanced. It would be unreasonable to deny recovery of costs incurred by the company in a plan that even the IE agrees properly assesses the risks and sets forth comprehensive programs to address the risk, because the company cannot yet quantify risk reduction of its WMP. The company has heard the recent concerns expressed by the commission and other parties that the increased cost of wildfire mitigation activities require more information to support a finding that the plan achieves the right balance of costs and risks. As I described in my rebuttal testimony on this issue, the company acknowledges the gravity of the task that has been placed on the commission to approve a plan that achieves a reasonable balance between rate impacts to customers and protecting the public safety. I firmly believe that the efficient and best path forward to resolve the disputes on the evaluation methods for wildfire mitigation plans is a separate proceeding where the various methods can be considered. If the commission declines to approve the 2023 WMP and requires the company to refile with a quantitative analysis, the resources of the parties will be expended on a litigation position instead of being used in a collaborative environment to create a reasonable expectation to guide the company's wildfire mitigation efforts in a way that everyone agrees is in the public interest for Utah. Also, given the scope of the company's 2023, given that the scope of the company's 2023 mitigation plan ends in 2025, it makes more sense to focus on evaluation methods for the company's 2026 plan than focus resources on a plan that will soon be beyond its scope. As to the appropriate level of cost to approve in the revenue requirement for this case, parties have argued that the commission should not allow costs and base rates associated with a plan that has not been approved. It is important to note that the amount being requested is reflective of what the company expects to spend on wildfire mitigation in calendar year 2025 test period. The base rates for this case become effective April 26, 2025. The corresponding wildfire plan for these costs ends at the end of this year, whether or not it is approved. So this amount in base rates will really be used to true up for the next wildfire plan that begins in 2026. Regardless of the approved or not approved status of a wildfire mitigation plan, it makes sense to set base rates to reflect the expected expenses in the test period. similar to how all costs are set in a general rate case. Turning to the $22 million in deferred cost associated with calendar years 2021 through 2023, parties have also objected to the recovery of these costs based primarily on two arguments: that the costs are not truly incremental to base rates, and that the cost associated with the unapproved 2023 plan should be denied simply because the plan is not approved. Shelley McCoy and Alan Barrett provide significant evidence in this case to show recovery of these costs is not a double recovery. Regarding costs identified as being associated with the 2023 plan, no party has argued the costs are not prudent. The company requests approval of the 2023 plan as well as the costs that were used to deferred to implement the plan. As we've discussed several times through this proceeding, wildfire risk is a significant public policy issue in the West, and Utah is not immune to that risk. The risk to Utah should not be discounted because we haven't had a catastrophic fire on the scale we've seen in other Western states. This risk is fundamentally altering how we do business as a public utility, including how we operate, how we plan, how we invest, and how we finance our day-to-day activities. Our wildfire mitigation efforts are a critical element to ensuring the safe delivery of our service to our Utah customers, and our mitigation efforts will continue to evolve. But until there is clear guidance, we believe our 2023 WMP should be approved. The plan meets the requirements of the law and balances costs and risks as we know them today. And this completes my summary. Thank you.
Thank you, Ms. Stewart, for your summary. Appreciate that very much. Mr. Moskin?
Thank you. Ms. Stewart is available for cross-examination and commission questions.
Okay, thank you. Ms. Schmidt, questions of the witness?
Yes, the division does have some. Good morning.
Good morning.
I'd like to start by asking you to clarify a couple of things that I thought I heard in your summary. I believe that the company has filed not only a 2023 WMP, but also a revised 2023 WMP. Is that correct?
Well, the WMP we filed, so we initially filed in October of 2023, I believe, and then we pulled it back, I can't think of the right word, and then refiled. And so it's really just the one plan that we refiled, I believe in February of '24. That is our 2023 plan.
Thank you. I think that I've been calling that the revised plan, but I'll just call it the 2023 plan from now on. Thank you. Also, I think in your summary, you said that the company is seeking to recover $22 million of deferred costs. Did I hear that right?
Yes.
The number that has previously been used was $21 million, I believe. Could you please explain if I'm incorrect and 22 million is the correct number? And
It may just be rounding, and Ms. McCoy and her exhibits have the precise number.
thank you very much. I likely will continue to refer to the number as 21 million because unfortunately I am a creature of habit. Okay. Well, to get started, could you please turn to page 7? Do you have your rebuttal testimony in front of you?
Yes.
Could you please turn to page 17 of your rebuttal testimony in Phase 3 and read lines 352 through 357 into the record?
Starting with while I am not.
Correct.
Okay.
Could I just interrupt for just a second, to put something on the record? I think Ms. Stewart did say on lines 18 and 19 of her Phase 3 rebuttal testimony, quote, approve the recovery of 21 million in deferred costs associated with calendar year 21 through 23 over 12 months. So, yeah, so that was the number you used in your testimony, I believe.
You're right. I also see I referred to 22 million on page 18.
Okay, I guess I should have pointed that out. I stopped on page 1, but anyway, we'll figure that out at some point in time. Thank you, though I'm sorry to interrupt you, but I just thought I would see if I was trying to clarify it. and maybe I didn't. Go ahead, Ms. Schmidt.
Could you please read those lines into the record? Again, they were lines 352 through 357 of your rebuttal testimony in Phase 3 WMP part.
While I am not an attorney, it is my understanding that nothing in the statute states that the utility shall not invest in or recover costs for prudent wildfire mitigation absent approval. In other words, the relevant statutory language simply provides utilities a guarantee of cost recovery and does not prohibit wildfire mitigation expenditure or recovery of prudent costs pending or absent approval.
Mr. Chair, may Mr. Grecu please approach the witness, the commission, and pass out DPU's cross-exhibit?
Sure, that'd
Thank
be
you.
fine.
Mr. Grecu is passing out a copy of Utah Code 54-24-101 through 202, and also a copy of the commission's relevant rule. They are stapled together in one packet, and the division would like to request that they be marked as DPU cross-exhibit 6, perhaps?
Melissa, do you know if that's the right number? We'll mark it as cross 6, and if when we go through the record, we find out that there already is a cross 6, then we'll mark it as 6B, okay? Just to not get everybody off track, okay, but DPU cross 6.
Thank you. Ms. Stewart, are you generally familiar with Chapter 24 of the Utah Code, the Wildland Fire Planning and Cost Recovery Act?
Yes.
Would you like to take a moment to review Section 5424-202?
That is not on the sheet.
I was gonna say, if I could ask, I don't have a copy of 202 in my exhibit.
You just have 203.
Well, I apologize, and that is interesting. May we take a break while we go upstairs and get a complete copy?
Sure.
Thank
Yeah,
you.
let's take Mr. Grecu is going to run, so it'll be 5-minute break.
Thank you
I
very
was
much.
gonna say, I have it myself, if that helps, but.
Did you hear that, Mr. Grecu? She has Section 202. I don't think you're going to need to get it. I mean, we can mark and take judicial notice of the fact that it's a section from the code, and if she can read from the code here, I don't think we need to add it to the exhibit unless, something comes up that's required. But let's see where you're going with this.
Thank you. And do you have the statute in front of you, even though I didn't provide it?
Yes.
And I apologize for that. It was an oversight on my part. Could you please point me to the language in 202 where the word guarantee or guaranteed is used?
Objection assumes facts, not evidence. It assumes that the testimony cited and had read into the record was in fact referring to this statute. So the fact that Ms. Stewart may or may not be able to point to that word does not necessarily go to this particular statute.
I think you raise a good point, but I think and that's noted on the record, but I think Ms. Schmidt can ask whether the word is, she's trying to inquire whether the word is in Section 202, and I'll let her go ahead and ask the question.
Sorry. The word does not, guarantee is not in this section, but it does say shall recover and rates all prudently incurred investments and expenditures.
Thank you. Let's talk about cost recovery just a bit more. Do you agree that the statute 202 requires that investments and expenditures be prudent for the company to achieve cost recovery?
Absolutely.
Do you also agree that the statute requires the prudent investments and expenditures be made to implement a wildfire protection plan?
I'm going to just lodge a running objection to the extent this is calling for a legal conclusion. Of course, Ms. Stewart's able to read the statute and give her thoughts about it, but to the extent that Ms. Schmidt or the division is seeking the company's legal determination of statute, we object to that.
Yeah, she would not be the right witness to give a legal opinion as to what the statute means, but I think, as you already know, and we'll give you a running objection to it, but as you already know, she can give her understanding as a lay person of the statute. You may continue, Ms. Schmidt.
As Ms. Stewart noted, she is not an attorney, so I am not asking for a legal opinion.
We knew that, but I think the objection needed to be made for the record, so thank you.
And can you repeat the question?
Of course. Do you agree with me that in order to recover costs under this section, the statute also requires that the prudent investments and expenditures be made to implement a wildfire protection plan?
Under this section, yes.
And finally, isn't it correct that the statute requires that the prudent investments and expenditures be made to implement an approved wildland fire protection plan under this statute?
I'm sorry, wasn't that the prior question? I missed the distinction.
What I'm trying to get with my third question is that we have investments and expenditures that are prudent, that must be made to implement a wildfire protection plan. And then to restate my question more clearly, to recover the costs, doesn't the wildland fire protection plan have to be approved under the statute?
Under this statute, yes. The cost in our rate case, though, are part of our test period. So I think there is a slight distinction.
So under this section, if the spending is not made to implement an improved plan, the cost recovery can't occur. Is that correct?
No, I don't agree.
Let's move on. Let's turn to a discussion of approving a WMP. Is it fair to characterize your testimony as saying that demonstrating the risks and costs are balanced is a new requirement for a WMP? And I'm referring specifically to around page 12 of your rebuttal testimony, lines 248-254, beginning with "instead of spending." And if you would prefer, please feel free to read those lines into the record.
I'm sorry, can you, I got, which testimony, which page?
Your rebuttal testimony,
Okay,
page 12,
okay.
lines 248-254.
Sorry, I was looking at 58.
Perhaps it would be best if you just read those lines into the record. Could you please do that?
Yeah, how far?
Beginning with "instead of" and ending with "balanced" on line 254.
Okay. Instead of spending resources on continuing to revise and evaluate a wildfire mitigation plan for a period that is almost over, the company recommends the commission focus on establishing a methodology for future plans and implement a path forward as follows. 1, approve the WMP, the 2023 WMP as the final wildfire mitigation plan that will be approved without the new requirements for demonstrating the risks and costs are balanced.
Following the paragraph that you just read, there is a paragraph number 2 that I did not ask you to read into the record, and I don't believe I will be asking you any questions about that.
Okay. I'm sorry, can you go back to what the first question was?
Of course. My first question was it a fair characterization of your testimony to characterize it as demonstrating the risks and costs are balanced is a new requirement, but that question, the need for that question has been eliminated because I asked you to read your actual testimony into the record.
To that extent, then, I'll object and say that the supposed implied answer to the question, in fact, misstates or misunderstands the testimony, which is not talking about a requirement from the statute, but from a potential further docket.
Okay, I think that the objection is noted. We'll allow her to answer. We'll have your objection on the record, and we'll consider this with respect to whatever weight we will give it. But I think you can ask the question again, or you can ask for an answer.
Thank you. I think to help clarify my question, could you please turn to 5424 201 3C and read that? And I'm asking about approval under this statute in particular.
Yes, it says, "The commission shall approve a wildland fire protection plan submitted under subsection 3A if the plan, little I, is reasonable and in the public interest, and little 2I, appropriately balances the cost of implementing the plan with the risk of a potential wildland fire."
Thank you. Isn't the company required to provide substantial evidence to this commission showing that the plan appropriately balances the costs and implementing the plan with the risk of a potential wildland fire under this statute?
I know we've already got the running objection to a legal conclusion, but we indicated Ms. Stewart can give her own interpretation of the words in a statute, but that question certainly goes beyond and is asking specifically for what the legal burden of proof is of the company. So I just want to note that that question, I think, goes beyond what was indicated as asking for lay understanding of a statute.
Perhaps
Yeah.
I could restate the
Yeah,
question?
Yeah, the objection's sustained,
I bel-
and you can rephrase the question to perhaps make it more acceptable to the attorneys from Rocky Mountain Power.
Thank you. Is it correct that in filed testimony in Phase 3, wildland mitigation plan part, that the company has stated that it bears the burden of proof?
Objection vague.
Noted, you can continue.
Will you accept, subject to check, that the company states that it bears the burden of proof in the company's pre-filed testimony in Phase 3, Part B?
Certainly, we bear the burden of preparing and evaluating wildfire risk and mitigation efforts to address that risk as part of our wildfire mitigation plan.
Thank you. I have no further questions at this time.
Okay, thank you, Ms. Schmidt. Let's go to, let's be Mr. Starr or Mr. Moore. Mr. Starr,
I'll be happy to take care of this part of the proceeding.
thank you.
Good morning, Ms. Stewart.
Good morning.
I have just a few questions about Rocky Mountain's efforts to comply with the wildland fire planning and cost recovery amendments that were enacted in 2020. In your Phase 3 rebuttal testimony, you note that the company filed its initial wildland fire protection plan on June 1, 2020. Is that correct?
Subject to check, yes.
Sure. Now, could you turn to page 4 of your rebuttal testimony?
Okay.
And at line 78, I believe you quote from a commission's supplemental action request directed at the Division of Public Utilities, which focused on section 5424 201 3C of the Act. Isn't that correct?
Yes.
Is it fair to say that the supplemental action request tees up the primary question that we're addressing in this phase 3?
Well, I mean, this is citing to a commission supplemental action request for 2020 plan.
And doesn't
I
it
guess I'm-
address the question about the plan balancing the risks and the potential fires?
Right, so that it is pointing to the same section of the statute that we just discussed, which is part of what the commission makes a finding on.
And so the issue that we seem to be struggling with was identified early by the commission, and it was identified in that particular document. Is that right?
Yes, and we're fully aware that that's part of the statute and part of what the commission has to make a finding on. But how you do that, I think, is the point of contention, and whether our plan, how deeply it quantifies every specific decision, I think is the challenge.
All right. Could you turn now to page 3 of your phase 3 surrebuttal testimony? I apologize for bouncing back and forth. It's just the way the issues seem to flow for my focus here.
Okay?
Commencing at line 53, you quote from the commission's order approving the company's 2020 plan, indicating that the commission stated that the act does not require the plan itself to expressly discuss and demonstrate that costs and risks are appropriately balanced. Isn't that correct?
I'm sorry, I'm apparently I'm on the wrong spot. I
maybe
went to
I'm
page 3. Oh, sorry.
Lines
I have-
53 and 54.
I have 2 rebuttals, sorry, that was.
Oh, I'm sorry.
I was on the wrong piece. Okay, I'm sorry. Page 3, line 55?
Starting at 53.
53, okay.
And the commission's order indicates that the act does not require the plan itself to expressly discuss and demonstrate that costs and risks are appropriately balanced. Isn't that correct?
Correct.
Now, can we assume that you do not construe that commission's language as negating the necessity of making a finding with respect to the Act's requirements about the balancing of costs and implementing a plan with the risk of a potential wildland fire?
Before she answers, I'd like to perhaps clarify my objection as to asking for legal conclusions. And one of the reasons we wanted briefing is there's a combining of rate case standards and approval of wildfire mitigation plan, which are different things and have different requirements. And I don't mind the witness being asked what her understanding of things is, but when you use the word requirement as it applies to a commission finding, but to impute to the company is actually a legal topic that we think requires a briefing, and I just don't want that to be waived or lost with respect to whatever lay answer is provided by Ms. Stewart.
I think you make a very good point, and we will, you're not going to waive a legal argument by Ms. Stewart responding, but Mr. Snar is asking her about her understanding of the 2020 order as a layperson, and the question of whether it negates the requirement of providing an analysis, I think, is an appropriate question. If you want to repeat the question, or you might have it fully in mind, Ms.
I think you have it fully in mind.
Well, Ms. Stewart, I have it in mind. Does Ms. Stewart have it in mind? Well, why don't you repeat it, I think, or we can have the court reporter read it back if you'd like.
I can read it here.
Okay, please, go ahead.
Can we assume that the commission's language there does not really change the requirements of the law?
That is my understanding, yes.
And that the commission, that Rocky Mountain is bound by the law and the commission is bound by the law?
Yes.
Thank you. Now, turning to the costs that the company included in its initial 2020 plan, isn't it true, and I'll let you check this if you wish, that the company sought just $40.5 million in capital investment and $4.9 million in O&M expenses for 2023?
Subject to check. I don't know that I have those numbers.
So we're talking about the first plan, we're talking about the 2023 year. Thank you. Now referring to your revised 2023 Wildland Fire Protection Plan filed. Would you accept, subject to check, that in that plan for 2023, the plan called for $103.8 million in capital investment and $17.9 million in O&M expenses for 2023?
I will accept that, subject to check, yes.
And also, in that revised 2023 plan, focusing on the year 2025, would you accept, subject to check, the plan calls for $156.9 million in capital investment and $28.4 million in O&M expenses for 2025?
I will accept that, subject to check.
Now, those increases shown in 2025 represent an approximate 350% increase in capital investments and a probably 580% increase in O&M expense for 2025 over what was included initially for 2023 in the 2020 plan. Would you accept that, subject to check?
Yes.
Thank you. Now, I'd like you to please turn to page 8 of your Phase 3 rebuttal testimony.
Okay.
There at lines 153 through 156, I believe you quote from a commission's order relative to the wildland plan that was pending, where the commission says, "We are now presented with a plan that proposes costs tremendously greater than those contemplated in the 2020 plan, and no party, save for Rocky Mountain, appropriately balances risks and costs." Have I quoted that correct?
Yes.
Isn't it true that in that same order, the commission stated Rocky Mountain has provided no analysis to demonstrate any assessment of cost relative to risk? I do have a copy of that order if you would like me to provide it.
Yeah, I don't have it with me.
Would you like to see the order?
Sure.
Sure. I have pages 7 and 8 isolated in a page here from that commission order. Mr. Moore will be handing that out to Ms. Stewart and others.
Oh. Yeah.
This is just the commission's order, and I have a line highlighted there. Perhaps Ms. Stewart could read the part that's highlighted.
RMP has provided no analysis to demonstrate any assessment of cost relative to risk.
Okay. Now, we've talked about the increases in the plans and in the various years. All these increases have been requested without the submission of evidence showing that the specific risks have been compared with the costs of various mitigation measures that might be employed to address such risks. Isn't that correct?
I disagree that we have not provided evidence. We have not provided quantification the way parties seem to want us to provide it, but that is very complicated, and Mr. Josh Jones can speak to that.
All right. But I'm asking specifically about the comparison of the costs associated with specific risks and compare that with the costs of various mitigation measures.
I'm going to object to vagueness, and again, she's indicated this, she's not the right witness, but risk is such a broad term in this context. I don't know how you begin to answer whether the company has identified the costs related to a risk.
We'll be happy to explore that with Mr. Jones.
Okay, all right, thank you, Mr. Starr. I think that sounds to me that would be more efficient.
I would like now to refer you to your rebuttal testimony. And I'm looking at pages 3 and 4 there.
Okay?
There you recount how the commission determined it would engage an independent evaluator to review the company's plan and to offer an opinion and provide a written report on the 2023 revised WMP, including whether it appropriately balances costs and risks. Isn't that correct?
I'm sorry, what was the citation? Where?
It's a discussion on pages 3 and 4 of the rebuttal testimony.
Are you talking about beginning on line 81?
Right, that is the first reference to the IE, was on page 4, line 81, 82.
What I'm asking is, the commission decided to engage an independent evaluator. And in connection with engaging that independent evaluator, there was a reason provided by the commission. Do you state that reason there?
I'm looking for a specific quote. I mean, yes, I mean, I do summarize that the commission ordered or determined that they were going to hire an IE and summarize their rationale.
And one of the reasons was whether the plan appropriately balances costs and risks. Isn't that correct?
Yes.
Thank you. You've also noted that commission stated that it would issue a notice of filing and comment period to take input from other parties and the company. Isn't that correct?
Yes.
And in connection with the follow-up orders by the commission and including the consolidation of that docket with the proceedings we are in, isn't it true that the commission did identify a time when that input could be provided to the IE report?
Yes, they set a procedural schedule.
Right. And the report was filed on January 9th, 2025, isn't that correct?
Yes.
Now I'd like to refer you to page 7 of your phase 3 rebuttal testimony.
Okay.
Now, among the various findings made by the IE, you acknowledge, do you not, that the IE stated it was unable to determine the 2023 WMP properly evaluated mitigation costs and risks because the company did not perform a risk spend efficiency, or RSE, or other cost-benefit analysis. Isn't that correct?
Yes.
And with respect to the IE's report, Rocky Mountain representatives, including witnesses Joshua Jones and Shelley McCoy, filed Phase 3 direct testimony on February 14 of this year, responding to that order. Isn't it correct?
I believe so, yes.
Within the testimony that they filed, was there any cost versus risk information presented to respond to the IE's concerns that had been identified?
No.
Okay. Are you familiar with the Utah Administrative Code rule that was promulgated by the commission to deal with the filing and approval of a utilities wildland fire protection plan?
Do you have the specific citation?
At Rule 746-315-2.
And I happen to have it, thanks
good.
to Ms. Schmidt.
I had one here, but we'll just identify the area of interest here. In that rule, I'd like to direct you to Rule 746-315-2, and I'm looking at subsection 3. I'd like you to read the entirety of that subsection 3 into the record, if you would.
The commission shall approve a qualified utilities wildland fire protection plan to the extent that the evidence in the record establishes that it, little I, is reasonable and in the public interest, and little 2I, appropriately balances the cost of implementing the wildland fire protection plan with the risk of a potential wildland fire.
Would you agree with me that the commission identified specifically a concern about having the evidence in the record establish the requirements of the plan?
Yes, I understand that that was part of the commission's orders, and I think the testimony that we have in the record that explains the challenges of that for purposes of the 2023 plan is addressed by Mr. Jones.
Now, prior to the enactment of the Wildland Fire Protection Plan Act, Rocky Mountain was concerned about wildfire and maintaining a safe and effective system, was it not?
Prior, I'm sorry, prior to to when?
Prior to the enactment of the Wildland Fire Protection Plan Act,
Yes.
2019, if you will.
Were we concerned about the risk of wildfires before the wildfire plan? Yes.
Sure. And isn't it true that without availing itself of utilizing a wildland fire protection plan and the associated wildfire mitigation balancing account, Rocky Mountain still has the opportunity to include prudent wildfire mitigation costs for recovery in its general rates?
Yes.
I'd like to now refer you to Sir Rebuttal Testimony, page 6.
Okay.
I'm looking at lines 115 and 116.
Okay.
With the opportunity to include prudently incurred wildfire mitigation costs in your general rates, isn't your observation there at lines 115 and 116 a mischaracterization of OCS's position?
I don't think I can say that based on that question.
Do you really believe that OCS is trying to prohibit you from making prudent costs to run your system?
No. The
Okay.
OCS is not trying to prohibit us from running prudent costs, but they are challenging our ability to get recovery of those costs, which is of significant concern to the company.
Recovery, you're talking about the plan that's in question and whether it meets the criteria for approval.
The plan and our rate, our test period costs.
You think OCS is trying to keep you from recovering prudent costs as test period costs in 2025?
I think there is a proposed disallowance to our base period rate case costs.
I'll let that stand. Now I'd like to direct your attention to page 7 of your Sir Rebuttal testimony.
Okay.
At line 131. I'm going to ask you a question there. Wouldn't it be more accurate to say that OCS has consistently suggested that the company needs to bear its burden of proof and comply with the statutes, both in its requirement to demonstrate a balance in costs and risks in order for the commission to approve a mitigation plan, and also meet the requirements to demonstrate that costs are incremental to base rates and associated with an approved plan in order for the company to avail itself of the benefits of that balancing account process?
Objection, argumentative. The question is merely trying to get the witness to agree to counsel's argument of what he understands the OCS position to be.
Can you rephrase the question, Mr. Snar. I think that it was long and complex, and I think that they've set forth what their position is in lines 131 through 132 of that sentence, but I think you could ask the question, it was, I'd add to ask you to rephrase the question if you could.
Is there a chance you've misunderstood OCS's intent in pursuing its course in this proceeding?
Potentially, yes.
Thank you.
Thank you for
I have
rephrasing
no other
that.
questions.
Okay. Thank you, Mr. Snar. I appreciate it. Okay, on the Utah Division of Forestry, Fire, and State Lands, I feel terrible about this, but I can remember that Mr. Bagley is going to testify, but I can't remember your name, so would you please state your name again for the record?
Yes, I'm Assistant Attorney General Carter Moore.
Should have been able to remember that, shouldn't I? Mr. Moore, do you have any questions of Ms. Stewart?
Forestry, Fire, and State Lands does not have any questions for Ms. Stewart.
Okay, thank you. All right, Mr. Russell.
Yes, thank you. Ms. Stewart, I'm going to have you turn to page 4 of your Phase 3 SIR rebuttal.
Okay.
Starting on line 71, there's a quotation there in your response to a question. That quotation quotes from the Commission's order for additional time in process in docket number 23-035 I think it's 44, which has been consolidated into this case. Is that right?
Yes. Is my footnote there wrong?
I
Yeah.
hadn't looked at the docket number in your footnote until I started talking, so I was doing that on the fly. But I think it's 44. In any event, it's been consolidated into this case. I wasn't intending to
You got
raise
me
a typo.
there.
Yeah.
Okay.
The quotation that I wanted to point you to is in your answer, and it says, quote, "While the record before us cannot support a finding the revised plan appropriately balances the costs and risks, it similarly could not support a finding the plan fails to do so. The PSC simply requires more information." And my question is, what is the additional information that the company has provided on the record that would allow the PSC to make a different conclusion here?
Well, and I think that's really in the testimony of Josh Jones, who explains the challenges and our history with the risk-spend analysis and how, as part of our plan, we can evaluate alternatives and prioritize costs to achieve that balance.
Okay, sounds like maybe I should have that conversation with him.
Sure.
Okay, thanks, that's all I have.
Okay, Ms. Hayes.
No questions, thank you.
All right, let's turn to Commissioner Harvey and see what questions he has. Oh, yeah, I'm sorry. I knew that. Are there any redirect, Mr. Moskin?
Just very briefly, Ms. Stewart, you gave an answer later that indicated perhaps that I thought you may have, maybe I misheard you or you may have misheard Counselor for the OCS. There was a question in which I understood him to be asking you whether the testimony in this proceeding filed by Ms. McCoy and Mr. Jones was responsive to the concerns of the IE, and I thought I heard you say no, and I wanted to clarify if that is really your intention to say that Ms. McCoy or Mr. Jones did not provide any information that would assuage any of the notations of the IE.
I can't remember how you started the question in order to answer yes or no, but yeah, if I implied that, I remember the question about them filing testimony on February 14th in response to the IE report, and I agreed they did file testimony, and I believe that does address,
Okay.
is responsive.
Perfect. Then just now, when counsel for the UAE was asking you what additional information has been put before the commission that was not there when it wrote the sentence that's on page 4 of your surrebuttal. And I think you appropriately pointed to the testimony of Mr. Jones. But would you agree with me that there's also additional information available to the commission from the IE and from the forestry department that could also supplement the record for the commission to make that finding?
Yes.
Thank you. No further questions.
Okay, thank you, Mr. Moskin. Now we'll go to Commissioner Harvey for any questions he has. Yes.
Hello, and thank you for being here. Just for my benefit to begin with, I want to find out which RMP witness I should ask particular questions to, but for questions about the mechanics and calculations within the actual plan itself, would those be addressed to you, or to other witnesses?
For the plan itself and the cost in the plan, that would be Josh Jones. For the accounting treatment, probably Shelley McCoy.
And then questions about the metrics that the plan develops, like its percentiles of risk and choosing consequence areas, would that be Jones as well?
That would be Josh Jones. And then Alan Barrett is also one of our witnesses, very capable of answering questions on wildfire mitigation, and he is explicitly discussing the deferred costs, so the historical costs. So between the two of them, they have a significant amount of depth on our wildfire mitigation plan and spending.
But they would not, it would not be you.
Yeah.
Okay, all right, so I'll save those for later then. All right. I'd like you to turn for a minute to that order that the OCS handed you, that one page, page
Okay.
7 and 8. And on page 8, the first full paragraph on that page, it starts in sum.
Yes.
Could you just read that into the record for me?
In sum, the only party contending the revised plan appropriately balances cost and risk is RMP, and it offers only conclusory statements without any analysis to support its representation. On the record before us, the PSC simply cannot find the revised plan appropriately balances the cost of implementing the plan with the risk of potential wildland fires.
All right. Would you characterize that language as fairly clear in terms of how the commission felt about the record?
Yeah, I mean, it is clear, but it is still, that there's a, how to do that evaluation, I think is complex and could be very much multifaceted. And so the details around what that standard is, the commission would like to see for a kind of quantitative analysis, which is what we took it, I think, from the IE report, that risk spend analysis. I think that is worthy of additional discussion. So as a state, we can all be on the same page about how to evaluate the trade-offs between cost and risk.
Okay, and I appreciate that clarification. Based on the extensive testimony and the cross today, would the company agree that the commission has to make a finding one way or the other with respect to whether the plan appropriately balances the cost of implementing it and the benefits?
I think so.
All right. And would the company agree that if the commission's opinion is the same as it was in this order that we previously quoted, that the commission, by its own words there, would have to make a finding that it didn't, because it said it couldn't?
I mean, I think it'd be quite a challenge for the company and our customers and the safety of the state to not be able to move forward with the 2023 wildfire mitigation plan. If the commission did, say the 2020 plan is currently still approved and in effect, but it is outdated, and those costs have significantly changed. And so, we believe very strongly that our ability to address this public policy issue, it's important that we have acknowledgement and can move forward with this plan. And so we're hopeful the commission, with the record, with the IE's report, that recognize we did identify the risk, we did identify the programs to address that risk. The plan will continue to evolve, and we welcome that discussion and guidance to do the next plan. But this plan, the risk in our state is too great to just revert back to the 2020 plan.
All right, this might be a question for Josh Jones, but you've just referred to the risks. In your mind, is that risk the cost of a potential fire times the likelihood of a utility-caused fire, or is it something else?
Well, I think that's part of the challenge of how do you define what the risk is. There's certainly a risk of ignition, but there's the risk of the spread. There's a risk around the circumstances that could create a catastrophic event that is outside of our control. There's also the risk of a fire that encroaches on our lines and us being held liable. I mean, there's just a number of risks that we have to address around this issue. And I think how to define what is that specific risk and how to quantify it, I think that's the challenge that we're having right now.
Mm-hmm. So I'm just clarifying, did I understand your answer to be that Rocky Mountain Power intends its wildfire mitigation plan to address more than the likelihood of utility-caused fires?
Yeah, as part of our situational awareness and our operational practices, yes.
Okay. All right. Would you agree that, given the previous orders that declined to approve the plan, that the company has made its own independent decisions about what it considers to be prudent in terms of the expenses that would be above the approved 2020 plan?
Yes, I mean, we always do, determine what we believe is prudent, and we recognize we have to demonstrate that. But because of this risk, we did not believe it was prudent to delay the activities of moving forward with mitigation efforts, particularly in light of the feedback we had from the FFSL on the initial filing, and then the support we had from them on the expanded FHCA area and the filed plan, in the February revised plan, as Ms. Schmidt called it.
Okay. So in this proceeding, meaning the consolidated case that we're in, we have a situation where we have expenditures significantly above the approved plan that Rocky Mountain Power bears the burden with respect to prudence. Would you agree with that or not?
Yes.
Okay. I'd like to explore with you a little bit further what you feel has changed, say in the last 10 years or so, that has driven this risk upward so much, that would justify these dramatic increases in spending above the approved plan. So if you can just sort of enumerate what specific things have changed that would justify, in your mind, these dramatic increases.
Well, and our operational folks, Mr. Barroth and Mr. Jones, can speak to the actual changes in cost associated with our mitigation activities, because those have gone up, particularly since the 2020 plan and then the expanded FHCA area. But, I mean, generally, I think the whole West has become very alert to the risk and the cost of catastrophic events that are largely attributable to changes in the climate. I think it's fair to say. I mean, as we have drier years here in our service area in Utah in particular, as we go through droughts, it creates a more risky environment for the risk of and the consequences of an ignition. But then broadly as well, the other side of it is the liability risk associated in the event there is a fire that is attributed to a utility. I think that it's the complexity around wildfire risk, as I mentioned in my summary, has just fundamentally changed how we operate as a utility and the risk around being an electric utility.
Okay. And has the Utah legislature passed laws and the Utah governor signed those laws that limit that liability?
So, yeah, I mean, the legislature has passed 2 laws. The law to establish the wildfire mitigation plan and the balancing account. And then, of course, last year, HB or SB, I get it backwards, SB 224 to address the liability issues. But it's hugely helpful to have that limitation, as we talked about last week, on non-economic damages to protect us from a potential nuclear-style verdict, which is like, the punitive non-economic damages associated with a jury trial. But we, as a utility, we take our role providing this essential service very seriously, and we cannot just rest on the laurels of having a cap on non-economic damages. We still have to have an underlying level of insurance. We still face an underlying level of risk. It's still important for us to balance all of these issues in order to address that risk for the state, for us to continue to operate as a public utility in the state.
Okay, so turning, hopefully finally, to prudency. You've agreed with me earlier that PacifiCorp has the burden of prudency for that difference between the approved and the actual. What metrics are available in the record, in your mind, for the commission to move from this previous finding that it simply couldn't make the finding because the record was incomplete, to now trying to make that finding that is prudent?
And I think the key there is metric. What does that metric, what is it supposed to look like? The metric implies that there's a specific quantitative analysis, and Mr. Jones, I think, can talk about that, but I think that's the crux of what we're struggling with at the moment, and we are very much open to that sort of guidance of how do we establish a metric. But even then, states that have done metrics in the past, California, who we do business in, and they've been one of the first states, if not the first state, to adopt wildfire mitigation plans and have had now a decade of experience and evolution with that plan. And the analysis around those plans, as Mr. Jones talks about, they're actually moving away from that. They recognize that a strict metric does not really address the risk of how much a cost can offset the risk of an ignition or a fire.
Would you agree that if the commission thought something was wasteful, that it couldn't find that to be prudent? That's just a hypothetical.
Sure.
And that a general hypothetical prudent standard would have to say there would have to be some benefit that outweighed the cost of the policy or action?
Generally, yes.
And this may be repetitive, and if it is, I apologize, but in my mind, I still need it clarified a bit. To start with this previous order language that I had read in the record, it said, the PSC simply cannot find the revised plan appropriately balances the cost of implementing the plan with the risk of potential wildland fires. What major parts of the record would you point to that would, now, later, that would rectify that situation?
Well, I think the IE report is very helpful in that regards. I mean, the IE looked at how we evaluate the risks and what are the mitigation tools we use in our programs to address those risks, and found that those were part of, I'm going to say best practices. He may not have said best practices. I don't remember exactly. And then, you know, Mr. Jones can talk about in more detail, certainly, how the risk spend analysis that the IE pointed to, the challenges of trying to do that. We are open to doing that, but it also takes experience and history and metrics and how to define all of that. And, you know, if that is something the commission wants to delve into to understand those trade-offs, we are very open to that discussion. But it was an evolving methodology that Mr. Jones has much more experience on, and it was not done for this plan. But I don't believe that precludes the ability of the commission to find that the risks have been appropriately weighed, and we have the mitigation tools in place to do that. And the plan itself lays out our strategy of how to address that risk. I mean, we try to be responsible and prioritize the mitigation efforts to address the risks that we face, and evaluate the different alternatives to do that. You know, we're not trying to say, you know, we need to go out and underground everything. It's a plan to address the risk over a period of time.
And Mr. Jones would be the witness to delve into those details with?
Yes.
Okay. But you would agree that the company, well, I'm assuming, you can agree or disagree, obviously, but based on that answer, with respect to what's been added to the record since this order, what you've pointed to is the IE's report primarily. Is there other information?
Well, the IE report and then Mr. Jones's testimony that characterizes our response to the IE's, you know, one concern about the risk spend analysis.
All right, thank you. That's all I have.
Thank you, Commissioner Harvey. Commissioner Clark.
Thank you. Ms. Stewart, good morning. My questions are going to be confined to the rate-making aspects of the balancing account, and I want to relate I'm going to offer you some numbers and see if you can help me reconcile them. Sorry, but if it may be Ms. McCoy is the more appropriate witness to address these, but at least the questions will give her an opportunity to prepare.
Yes.
So first, I'm looking at an exhibit submitted with her rebuttal. It's SEM 2R3. And the numbers, the Utah allocated numbers associated with Utah Wildland Fire Mitigation Balancing Account base calculation. That's the heading of the exhibit. The numbers I'm interested in are first the revenue requirement number of basically 49.1 million, the expense number of 30.9 million, and the rate base number of 193.8 million. What I'm trying to understand is how the expense and rate base numbers relate to the numbers that are on your page 2 of your rebuttal testimony, where you provide the capital and expense associated with the 2025 plan.
And I don't have Ms. McCoy's exhibit with me, so I think that was a good preview for Ms. McCoy of the questions that
It's
she will
not
get.
something that you're immediately conversant with. So-
No.
Okay.
no.
And do you know the revenue requirement associated with the 2025 test period that relates to the wildfire mitigation plan for that year?
No, my testimony that you just pointed me to, page 2, just has the capital and the O&M, so it doesn't have the revenue requirement.
Right, okay. I'm looking at an exhibit that's in the IE report, but I think the company probably provided the numbers. On page 35, table 12, there's a 2025 capital number of 156.9 million, which ties to yours on page 2. There are capital numbers for 2023 and 2024 also. 2023 being 103.8 million and 2024 being 111 million. Would I be correct that those capital numbers are in the, those capital investments are in the rate base that is presented as the 2025 rate base in your general rate case proceeding here?
I believe those would be part of the deferral for Schedule 97. That's in the case.
And what's the amount of that deferral?
21 or 22 million.
So I understood that to apply to years 2022 and 2023, but we've got capital here from 2024, and one of my questions is, where is that?
It's not in this case. So that would be part of the mitigation, the wildfire mitigation balancing account that we would file this year. So
Okay.
those numbers are, you don't see those here.
Okay. And so in the rate case, we wouldn't see a return, or we wouldn't see a revenue requirement that reflects a return on the 111 million. That is the 2024 capital expense. Is that correct?
Yes, and since I don't have what you're looking at, I mean, that may have been the cost in the plan, but would be, in our deferral will be the actual.
Okay, right. But the 21 million or 22 million, does include a return on the capital that was expended in 2023, is that correct?
I believe so, but I am going to defer to Ms. McCoy, who has the actual calculation to ensure that it does include the capital and the return.
Okay. And I have similar questions about the O&M for 2023, and I'll assume that your answer regarding 2024 O&M would be the same as for the capital, that it would be, it's not, you haven't yet sought recovery for that, and that would happen later in a filing associated with the balancing account.
Yes, for incremental O&M, yes.
Okay. Right. Incremental O&M. Now I'm going to do, I want to just ask you about some numbers that are from the 2020 general rate case. I know you don't have them in front of you. I'm just going to ask you if you have any reason to believe that they're somehow incorrect. I'm looking at a work paper from the case that expresses 2021 revenue expenses, or I'm sorry, revenue requirement expenses and rate base for the Utah Wildland Fire Mitigation Balancing Account for 2021.
Okay.
And so the revenue requirement is about $9.5 million, and the expense is about $5.8 million, and the rate base is about $41.1 million.
Okay.
And I do those numbers sound reasonable to you, or would you have any reason to dispute their?
No, I have no reason to dispute that.
Okay. Thank you. Those are all my questions. Thanks very much, Ms. Stewart.
Thank you, Commissioner Clark. Ms. Stewart, in your revised plan filed in February, you referred to the risk-spend efficiency analysis that was being undertaken by the company. Do you have any understanding or general observation about when that risk-spend efficiency would be completed by the company?
My understanding is, I believe they're working on it for this year, but Mr. Jones oversees that, so
Okay,
we'll have.
I'll ask those questions to Mr. Jones. When you read the commission's order issued several months ago about where in the commission made the statement that it was simply didn't have enough information to evaluate the costs and risks to perform the analysis as required by section 54-24-203, which, let me just read, says that the governing authority shall approve the wildfire plan submitted under subsection 3A if the plan, one, is reasonable and in the interest of the electric cooperative members, and two, appropriately balances, this is under cooperative, that's under the wrong section, there we go. Is reasonable in the public interest, and two, appropriately balances the cost of implementing the wildfire fire protection plan with the risk of a potential wildland fire. So the issue of balancing costs versus risk of a potential fire, you're aware that that is a requirement of the statute.
Yes.
So once you saw the commission's concern, do you give any thought as a company and in your regulatory environment of trying to provide perhaps an illustrative case of the costs for a particular line rebuild or mitigation efforts on a line, such as the cost of undergrounding versus the cost of covered conductor versus the cost of an aggressive vegetation management plan and the associated risk reduction of any of those three plans?
We did not contemplate I don't recall any discussions about trying to modify our plan or somehow amend the plan based on that order. I mean, that was, and part of it is like having a moving target during a procedural, through a process. The commission identified that they were going to hire an independent evaluator.
Yeah.
And it didn't seem, we weren't sure how long that was going to take. I think it ended up taking a little bit longer than we thought it would. And so, but we hadn't undertaken changes to our plan. We didn't want to modify what was before the commission and sort of change the target on everybody in the parties until there'd been an opportunity to review that plan. And so we were just sort of in it didn't seem like it was the right thing for us to refile something. So, no.
Yeah, I understand that, and I note your comment about it taking longer than you anticipated to get an independent evaluator's report. Frankly, it took longer than we anticipated too because of some of the issues with respect to the procurement process. But be that as it may, do you think it would have helped the commission in evaluating the plan to provide in your rebuttal or rebuttal testimony more granular detail about, just take one line as to the analysis as to whether you do undergrounding, covered conductor, or vegetation management, and what the corresponding risk reduction for that particular line? Do you think that would have been helpful for the commission to have that information?
I think on the basis of you asking that question, yes. I think it sounds like it probably would have been.
Yeah.
And that is why we are very much open to taking this out of a litigated proceeding. And for the next plan, let's figure out what folks need to see. I mean, Mr. Barrett and Mr. Jones can speak to how we look at the cost of alternatives, the cost of undergrounding versus whatever else we do.
Yeah, I appreciate that, and perhaps those are questions to ask of Mr. Barrett and Mr. Jones. But my question really is whether more granular data with respect to the plan to choose among, let's say, three basic alternatives, and how you arrived at that, would that have been something, perhaps in hindsight now, that you think would have been valuable to the commission to have?
Yes. I mean, in hindsight, probably. Or just yes, not probably. But, I mean, they do look, I mean, when they're undertaking, major efforts, they've done a lot of work, up in the canyons, that they do a quantitative analysis around that. And so we do have a lot of information on individual pieces that are being done. And it feels like perhaps there was having that specific detail. It's a balance of how much detail do you put in a plan for under the statute versus the individual decisions that they make for the different circuits. And how much you the company may be held to something that's in the plan for a specific cost, because something could be in the plan for 2026. The cost can materially change between now and then from the cost of crews, the cost of wires, whatever kind of equipment's needed.
Sure, and I understand that, and I'm not suggesting that you would have filed a second revised plan in the context of this general rate case, but my question is, not even necessarily in hindsight, but do you think more granular detail of the costs of the various alternatives associated with the corresponding risk reduction of choosing one alternative over another for a specific line, just, it's, instead of the system-wide, but just giving an illustrative case, was that something that you contemplated providing but just chose not to?
No.
Okay.
I would say I don't know that we did contemplate providing that. We also didn't have, I'll leave it there.
Okay.
And if that was potentially a miss on our part, and that's why we would love to get this out of a litigated proceeding.
Yeah, and I appreciate very much your statement about trying to be collaborative. Frankly, I expect to be here another 6 years, and I think trying to work through with the various parties and be collaborative has its advantages, rather than each going to their corners and come out fighting. So I appreciate your comments on that. With respect to your comments about opening another proceeding wherein you would hope to get more guidance, is there any other alternative that you can think of instead of opening a separate docket, kind of a generic docket on wildland fire mitigation?
I suppose it could be just through some technical workshops,
Yeah.
either initiated by the company, or I don't know that it has to be under a docket, but I think it would be valuable for it to be a public noticed process, to have people at the table rather than just the company inviting people. I think we'd like to have the commission engaged in that as well.
What about instead of another docket, you will be filing a 2026 through 2029 wildfire plan next year, based upon the filing of the last plan. I understand it was filed in, I think, October of 2023.
Initially, yes.
Yeah, the initial plan.
It's due by October 1 every third year.
Yeah. And before you file the plan in 2026, it could be a docket opened on the plan with technical conferences. What you're saying is, if you want more direction, well, there's ways to do that. It either could come in the order in the general rate case, or it could come through a technical conference, maybe in that docket on the 2026 through 2029 plan, in advance of when you actually have written the plan. That's fair assessment, don't you think?
Yeah.
That Mr. Barrett and Mr. Jones would be the ones who would have the granular detail on that. They would be the ones to ask those questions. So I have no further questions.
Okay.
Ms. Stewart, thank you very much for
Thank
your
you.
multiple appearances here and your patience and answering the questions that have been propounded to you. You may be excused.
Thank you.
Thank you. I think now's a good time to take a break, all right? We'll take a 15-minute break and come back just a minute or two after 11 o'clock. Mr. Moskin, you can call your next witness.
Thank you. The company is going to call Mr. Joshua Jones, but while he's on his way up, I was just going to note that in a sidebar with counsel for the DPU, we have stipulated to a substitute in Cross Exhibit 6 that has the full statute that the DPU wanted, so that if they refer to other witnesses, it will be there.
Okay, I think that's great, because I was looking at a section that wasn't the right section, because I didn't have the other section.
And I apologize for that.
Yeah, that's fine. Before we swear Mr. Jones, I just have one thing. We may not finish with Mr. Jones before, we have a hard stop at noon because of other commitments. We'll take the hour lunch break then. So if we're not done, I'm apologizing, we won't make you stop in mid-sentence, but we'll end for a break at noon.
I hope
Okay.
I'm done by noon.
And then finally, right before you swear him, to the extent this is helpful, clarifying that the 22 versus $21 million discussion we had with Ms. Stewart, that it should be 21 million.
Okay.
So we would correct any testimony of hers, which is at her lines 325, 329, or 387, to read 321. Or,
Okay.
excuse me, to read 21 million.
Yeah, and I thought that was the case because it's both in her introduction and in her conclusion that it's 21 million, so I've assumed that's the number all along. Okay, Mr. Jones, will you raise your right arm to the swear? Do you solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated. Thank you. Mr. Moskin.
Thank you. Good morning, Mr. Jones.
Good morning.
Would you please state your name and tell us your title at the company?
Yeah, Josh Jones, Vice President of Asset Management, Wildfire Strategy.
Okay, and would you give us just a 15-second version of kind of your background and what your responsibilities entail as it pertains to wildfire and wildfire mitigation?
Sure. Been involved with Pacific Corp and the utility industry for the past 20 years. Spent 20 years with Pacific Corp, 4 years with Berkshire Hathaway Energy, our in corporate our parent company to Pacific Corp. Most of my time has been spent in reliability, asset management, operational practices, and implementation of wildfire mitigation.
Okay. Now, I show that you filed and previously had admitted Phase 1 rebuttal testimony with an accompanying exhibit. With respect to this phase of the case, the Phase 3, I show that you filed Phase 3 direct, Phase 3 rebuttal, and Phase 3 surrebuttal. Is that correct?
That is correct.
Are you aware of any mistakes or changes that we need to be, any corrections that need to be made to that testimony?
I am not.
So if we were to ask you the same questions, your answers would be the same as set forth in that testimony.
They would be.
The company moves for the admission of the Phase 3 direct, rebuttal, and surrebuttal testimony of witness Joshua Jones.
Okay, thank you, Mr. Moskin. Is there any objection to the admission of the Phase 3 direct, rebuttal, and surrebuttal testimony of Mr. Jones? Seeing none, that testimony is admitted.
Thank you. Mr. Jones, have you prepared a summary of your Phase 3 testimony?
I have.
And would you share that with the commission?
Yeah. Good morning, Chair Finn, Commissioner Clark, and Commissioner Harvey. My testimony, rebuttal, and surrebuttal in this proceeding summarizes key elements in the 2023 revised wildfire mitigation plan. It confirms that the revised plan addresses the concerns raised by the Utah Division of Forestry, Fire, and State Lands, a governing authority as outlined in Utah Code 5424-201, and that revised plan is compliant with Utah Code 5424-201 as confirmed by the independent evaluator. Additionally, my testimony, rebuttal, and surrebuttal testimony outlines how the Commission can make a determination that the 2023 revised wildfire mitigation plan balances the cost of implementing the wildfire plan with the risk of a potential wildland fire. While multiple parties in this proceeding would like to change Utah Code 5424-201 to require the company to summarize wildfire mitigation, a very complex and constantly evolving risk down into a simple cost-benefit analysis. That is not possible, nor is it consistent with how plans are developed and executed within the wildfire mitigation community. Utah Code 54-24-201 outlines that the approval of a wildfire plan must be based on the findings that the cost of implementing a wildfire plan is balanced on the risk of a wildland fire. The company has developed a very comprehensive and robust wildfire risk model. The wildfire risk model models the potential for both a wind-driven and fuel-driven wildfire, with consequences of fire determined by acres, structures, and loss of life. The entire service territory is modeled and using a composite score, and only the top 15% of the risk is designated as a fire high consequence area. While wildfires can occur anywhere within the state, the fire high consequence area is where the company targets system hardening, which is the most costly part of the plan. This in itself shows the first element of balancing the plan. The company is not rebuilding all lines that have risk at any cost. The plan has been prioritized to target only the highest risk areas for system hardening. The Utah Division of Forestry, Fire, and State Lands concluded that the 2023 revised wildfire mitigation plan satisfies the concern raised in the original 2023 wildfire mitigation plan. The independent evaluator also concluded that the company appropriately modeled the risk and set forth a comprehensive plan to mitigate the risk. Wildfire mitigation actions are determined by the wildfire risk through a governance process, a detailed scoping and design process, which the company has performed on all the wildfire mitigation activities. Mitigation work is also competitively bid to make sure that the mitigation work is in alignment with market rates for this work. For system hardening, each high-risk circuit is reviewed to determine the appropriate mitigation based on the risk modifier, circuit topology, and the ability to construct. Multiple parties in this proceeding would love for there to be an easy lookup chart based on the risk score, but that's not realistic nor consistent with the industry. One has to take into account the factors such as where the lines are in a canyon, near a road, as an example, or going up over a mountain. How many bends does that road? What is the vegetation type and what is the condition of vegetation? The company balances through its governance process, detailed scoping, and competitively bidding process in the second part of that element. The company recognizes the desire by parties to have a more defined model for evaluating plans like risk-spend efficiency, and in response, we have requested a separate docket to confirm these models, the inputs and the use of the outputs, and treatment against the approval of the plan or associated costs in a well-understood and adequate timeframe for the integration to be established within the plan. Using risk-spend efficiency or a model like the OCS recommends as the determining factor to approve the plan or associated costs is not reasonable or in alignment with the industry. Risk-spend efficiency or an equivalent model should only be used for alternatives analysis, and it is important to note states like California are already moving away from risk-spend efficiency. The company serves within California and has approved plans in California, and it is important to note that risk-spend efficiency is not used to develop or approve plans, nor is it used as a sole determining factor in the approval of plans in the state of California. The company is working through the proceeding in California to develop an approved process, as we do in other states and is recommended here. My testimony demonstrates that the company has developed a wildfire mitigation plan fully compliant with Utah rules and codes. The company adequately responded to a governing authority as outlined in Code 54-24-201, the Utah Division of Forestry, Fire, State Lands, with a submission of the 2023 revised wildfire mitigation plan, which satisfies concerns with the original 2023 wildfire mitigation plan. The company has provided evidence showing that the cost of the mitigation plan is balanced with the risk of a wildland fire by first developing a wildfire risk model for the entire state and designating only the top 15% as fire high consequence areas for system hardening, the largest cost of the mitigation program. The company is not mitigating all risks at all cost. Having a defined governance process for the selection of mitigation, rigorous scoping and design process, and competitively bidding mitigation work to confirm that work is in alignment with market rates. This concludes my summary.
Thank you, Mr. Jones. If I might be indulged by the commission, before I turn you over for cross-examination, Mr. Jones, you were here present in the room when there was questioning of Ms. Stewart regarding the company's wildfire plans.
Yes.
Can you briefly, just using a hypothetical example, for the commission, walk through how the company selects a project for mitigation, makes a determination of what the appropriate mitigation is, and then looks to ensure that it is implemented prudently?
Yeah. So we start out by modeling the entire service territory for the potential for a wildfire risk. It looks at two different elements. One, the potential for a wildfire to be caused by a wind-driven fire concern or by a fuel-driven fire concern. We aggregate that into a composite score, and that composite score is applied throughout the entire service territory. We designate the top 15% of that risk, which is where we typically see the emergence of catastrophic fires or the potential for catastrophic fires. And we select that for system hardening. The other 85% is mitigated through things like real-time modeling of our meteorology or operational practice changes and things of that nature. Moving back to that top 15%, which is the greatest risk, we target the lines that have the greatest composite score risk potential, meaning that they could lead to a wildland fire driven by one of two elements. It could be driven by the element of a wind-driven fire or by a fuel-driven fire. The selection of that circuit then goes through a scoping process to determine what is the appropriate way to mitigate that risk. As an example, let's say a line is traversing through a canyon. We would look at the ability to construct that first overhead, which is typically lower cost compared to doing it underground. And we would look at what is the potential to construct in that orientation. Now, there may be provisions in the canyon where there is already conduit to be able to pull that conductor in, which would make it the lowest cost option. Or if you look at the ability to remove that vegetation, that ability to remove the vegetation may not be there, and you may need to select a mitigation like undergrounding. And so we go through that process on the constructability of recommended mitigation activities within the wildfire community, primarily covered conductor or undergrounding in the system hardening area. Once we go through that selection process, we go through a detailed design looking at is that the appropriate line?
Pardon me?
Yep.
I'm wondering if this might be a more appropriate answer for a redirect question rather than a buttressing of his pre-file testimony, which is what it seems like to me.
Well, I think that's what he's trying to do here, but I think this is a helpful discussion, and frankly, I think it will give you more information that you can then follow up on cross. So I'm going to allow Mr. Jones to complete his summary of the process. I don't think we need another 20 minutes of this, but you're probably pretty close to being done anyway.
Yep. And so after we go through the design, we competitively bid that work, making sure that the work activity for that mitigation is done in alignment with competitive rates for that type of work activity. For example, covered conductors should be consistent with covered conductor market rates. Undergrounding should be consistent with undergrounding market rates. And it does take into account factors like soil condition for undergrounding or the orientation throughout a canyon, or does it traverse up over a mountain range where we would then have to address vegetation and things of that nature. So.
Okay, thank you. Now, Mr. Chair, in a similar vein, they're all much shorter, but 5 other questions I was going to ask that it's true. I could save and do that as redirect, but I do think that it will actually be more informative for the parties in commission and have a better flow for cross if that's done now, but I don't want to presume, so I will indicate I think this will be helpful to the commission based on its earlier questions.
Well, that was my initial response, as you heard me just a moment ago, but I'd like to see what others have to say about that. I mean, the questions would come in on redirect, likely, because of the issues that'll be raised on cross, but I would think that this might be helpful to you to frame your cross-examination to hear, I mean, how much longer do you have? Just a few minutes?
I have 5 questions, none of which are the giant summary like that, so I would literally think less than 5 minutes, but.
All right, is there, anybody want to restate their objection to that process, or are we okay with that? I see no objection to it, and we're going to allow you to ask your 5
Okay.
questions.
All right, thank you. Mr. Jones, there's been repeated reference in this proceeding already to this code 5424-203 and the provision in there that talks about a plan that appropriately balances the costs of implementing the plan with the risk of potential wildland fire. Are you familiar with that section? Did the company think that balance in that statute, balancing costs and risks, was referring to some type of mathematical type analysis?
We did not, and it's probably important to note that that's not consistent with what we see in other jurisdictions or states or the wildfire community. Typically, that type of analysis is performed on alternatives. Risk beneficiency is typically applied in an alternatives analysis, not being applied comprehensive to the total plan.
So then, could you just give an example of a hypothetical, what would an unbalanced active mitigation be?
Yeah. So if we were to take, target it again within that 15%, right, top 15% of our risk, and it's identified for a need for a potential for wildfire mitigation system hardening. In that, let's say that it's primarily a wind-driven risk, or let's stay with it's a wind-driven risk. With that, we would look at what is the cost for that and there's really no vegetation, relatively low vegetation. With that, we would select covered conductor. An unbalanced comparison would be to select undergrounding in that situation. Even though it is wind-driven, the potential for vegetation or other elements to be blown into the conductor and result in an ignition is lower. And so the selection of covered conductor would be the appropriate one. We typically see cost per mile about 1.3 for covered conductor and about 2.5 to 3 million per mile for underground conductor.
Does the 2023 plan, the current version of it, contain more, less, or equivalent information than the 2020 plan that was previously approved?
The 2023 and 2023 revised plan both include more analysis. It moves from a risk model that was performed by REACTS on a smaller subset of area and some internally developed models to in the 2023 plan as well as the 2023 revised plan. It moves to the industry standard, which is the Technosilva risk model.
Okay. And finally, what information are you aware of that the company had presented to parties, but I think we've now figured has not been made apparent to the commission that would show the cost of mitigation and how that has been spent?
Yeah. So through a lot of data requests as well as going through the independent evaluator process, we supplied a number of what's called investment appraisal documents. And in that investment appraisal documents, it's projects that are over $1 million. It goes through what is the risk score, what was the reason for selection of that mitigation activity, what are the deliverables associated with that, and what is the expected time frame as well as potential constraints. Some of those constraints may be that this is a radial line that has to be built in segments because you can't take the entire community out of service while you rebuild sections of that line.
Okay. Those are the follow-up questions I had. I will indicate to the commission that if it'd be useful, that type of data that the parties have but the commission does not have could be shared, filed, appended to post-hearing briefs if it would be useful. But with that, I'll turn over the witness for cross-examination.
Okay, I'm not going to respond to that right now, but I'll go to Ms. Schmidt for cross-examination, but it sounded like you had a objection or concern that started to come out of your mouth before I jumped in.
I do have a question or concern. The company has the burden of proof in all these dockets, as the company has acknowledged. The company has not chosen to provide as evidence those data request responses so far, and it seems unusual, perhaps even improper, for the company to seek to add information as evidence in its pre-hearing, in its post-hearing brief, rather than during the regular process.
Noted and well taken. Frankly, my question was directed to why we didn't get more granularity in the revised plan. And so, that was the time to have provided it, I think. But, okay, continue on. You can now begin your cross-examination.
May I add an objection?
Yes.
This comes at a time when we're past rebuttal and we're past surrebuttal and we're on the stand doing surrebuttal or trying to patch the holes in the framework of their case.
Yeah.
The commission expressed concern about what was missing in its order that has been talked about, the one that we used in cross-examination. You hired an independent evaluator to figure out what was in the plan and what wasn't in the plan. And there's a lot of stuff they put in it.
Right.
But there was stuff that wasn't in there that demonstrated this appropriate risk balance analysis in the process of determining where they're going to spend their money. And that's in there as a matter of law. And it in part is so that you as commissioners can balance what they're spending with what ratepayers can afford.
Correct.
And now we're kind of getting a chance for having evidence thrown in that might address that when the witnesses, Jones and McCoy, took the opportunity to provide responsive evidence to the EI report, and yet it wasn't in there. And so I'm a little concerned about the process. We're kind, we're helpful, and it seems like we're opening the door again to let them try to solve the problem. And yeah, there is a requirement in the commission's rule, not that there just be a balancing of the potential wildfire risk and the cost of implementing the particular plan, but there's a requirement in the rule that there be evidence in the record that establishes that. Now, it's not your responsibility to put the evidence in the record. It's not the OCS's responsibility to put the evidence in the record. It's their responsibility, and we're playing catch-up in the middle of this hearing. I object to it.
Well, I'm going to sustain that objection because I think that the opportunity was provided in filing the revised plan and then through a series of testimony, both that came in phase one and then specifically the testimony that came in phase three, rebuttal, direct rebuttal and surrebuttal. We're not going to open this up for more evidence to be submitted that is not then subject to cross-examination in post-hearing briefs, okay? So where the record is the record on these issues, and we're not going to supplement the record. The commission will make a determination whether the statutory provisions are complied with and whether the expenses were prudent based upon the record before it. So your objection is sustained, Mr. Snar.
Thank you.
All right. Now, we're going to go back to cross-examination.
May I have just one brief moment? Very brief.
Absolutely. Sure. You can have a longer than a brief moment if you need it, but remember we're breaking in 33 minutes. But go ahead and take what you need to resume. We'll go off the record for just a moment.
I will think very quickly. I am.
I'm sorry. All right, Ms. Schmidt, will you please move forward with cross-examination?
Are we back on the record?
We are, I'm sorry, I
That's
should have
okay.
noted that. When I turned my mic on, I figured that would be adequate notice, so we're back on the record, but yes.
The division has no cross-examination questions for this witness at this time. Thank you.
Okay, thank you. Mr. Snar, do you have cross-examination?
Yes, I do.
Please proceed.
Good morning, Mr. Jones.
Good morning.
I'd like to ask you a few questions concerning your testimony filed in this Phase 3 consolidated proceeding. Your Phase 3 direct testimony was filed on February 14 of this year, is that correct?
That is correct.
And the focus of that testimony was in large part to provide Rocky Mountain's response to the report that was filed by the independent evaluator. Is that right?
That is correct.
Now, please turn to page 1 and 2 of that Phase 3 direct testimony.
I'm there.
There you summarize the assignment that was given to the EI by the commission by identifying 3 tasks. Is that right?
And you're referring to lines 20, I assume?
Yeah, you have three tasks identified there. Is that right?
I believe if you were in reference to line 20, 21, 22, 23, and 24.
Yeah,
of
now, the
page 1 and
third
2.
task is to determine whether the company properly evaluated mitigation costs and benefits of its WMP. Is that right?
That is what it says?
And the task was identified because the statutory requirements of the Act sets forth that the requirements for that kind of balancing test. Is that right?
5424-201 sets forth that you need to show a balance of the cost of implementing a wildfire mitigation plan with the risk of a wildland fire.
Now, you've testified about some of the emerging industry practices, haven't you?
That is correct.
Now, and particular reference was to California, is that right?
So I need to provide a little bit of context. So the independent evaluator identified a way to potentially enhance the wildfire mitigation plan. And in there, they proposed PG&E's risk spend efficiency. And so my reference to California is mostly based on the IE's report, which this direct testimony is in response to. Now, I'll make note that the company actively participates in other jurisdictions for the development of these types of models, California being one, Oregon being another one. We participate in a number of industry forums, as well as joint IOU sessions, mostly outlined by commissions in those states.
Mostly outlined by commissions in various states, right? Do you know whether or not the California evolution of these processes was statutorily driven or commission driven?
I can't speak to where it originated, only our participation in those proceedings.
But you've testified that it's kind of evolved over time, is that right?
That is correct, it's evolved.
What about Oregon? Is that statutorily driven, or is it just something that has been driven by a commission there?
So I can't speak to the statutory piece, I can speak to the commission-driven piece. The Oregon Commission outlined, similar to what we are recommending here, a workshop to go through the appropriate elements of a risk spend efficiency or an equivalency model. In that, we have been participating with other joint IOUs at the recommendation of the commission to go through what data elements are appropriate to be used as the inputs, what are the appropriate outputs or scalability of those outputs, and what is the treatment of the use of those outputs against the plan. Those.
Let me ask a question now.
Can I finish when those are going to take place? So those are going to kick off next week and go through May. So we're actively involved in those.
Do you recall when the act was made law here in Utah?
It would have been either 2019 or 2020. I don't.
Right.
recall
Now,
the exact date.
are you aware of the collaboratory efforts that Rocky Mountain undertook prior to the enactment of the law in Utah to seek all the input from all the stakeholders so that that law might reflect the evolution and the compromises that would take place that you're seeing in these other jurisdictions?
Correct. I do recall that. I was the one that overseen the development of the 2020 wildfire mitigation plan. We sought input from the Utah Division of Forestry, Fire, and State Lands.
No, I'm referring to the legislative effort to create the law.
I can't speak to the legislative effort.
Would it be fair to say that Utah decided on what the law should be, and that was what was enacted?
Objection vague. When Utah decided, I'm not sure I understand the
Could
question.
rephrase the question,
I'll
Mr. Starr.
rephrase the question. Is it fair to say that the legislature of Utah somehow decided what the mitigation plan ought to look like and what the requirements were going to be for the state of Utah?
That is correct. Yep.
And it wasn't to pinpoint a particular evolution, it was just to set forth the requirements.
Set forth the requirements, the elements that need to be within the plan. That is correct.
Right.
Yep.
And so the state of Utah may have been in the forefront of identifying what was required, or maybe even behind, but somehow we got a particular statute.
So where was it at within the time frame of the evolution? Australia's been dealing with this for over 40 years. We've seen the first emergence of this in Texas in 2001, and then followed by California that has been going on for close to 2 decades. So yes, Utah did follow after other jurisdictions. That's correct.
But as Utah enacted a statute to address this issue, we had something at that point in time with definitions.
Correct, and we complied with those.
Oh, that's the question we're going to deal with in the hearing here.
That's what the independent evaluator concluded, is that we had met all the elements of the Utah code.
But would you agree with me, it doesn't matter what's evolving in the other states, as we have a particular statute we need to comply with in Utah?
I understand your question.
What's the answer?
Can you restate your question?
Do you understand that we have a particular set of requirements in the statute in Utah, and those requirements are not flexible or fungible or different, or they're not going to evolve in time unless this legislature decides to change that statute?
Objection. First of all, it's vague and argumentative and calls for a legal conclusion and implies that there can be nothing to be gleaned or learned in how to interpret a statute from other jurisdictions, which is commonplace in tribunals.
I'll withdraw the question.
Yeah, I was going to sustain your objection, but you could attempt to rephrase it if you'd like and ask it a different way. It's up to you.
Thank you. I'd like you to look at page 2 of your Phase 3 direct testimony.
Okay.
At lines 29 and 30, you indicate that the EI report was unable to determine whether the company properly evaluated mitigation program efficacy or mitigation cost and benefits. Is that correct?
That is what it says.
Now, at the top of page 3 of that testimony, you indicate that Pacific Corp is in the process of developing a risk spend efficiency, or RSE, evaluation tool, but that the tool had not yet been employed in the development of the revised 2023 WMP. Isn't that correct?
That is correct.
Thank you. Now, I'd like you to refer to page, let's see, do you have the, maybe I can do this a little easier here. I have a copy of page 41 of the EI report. I'd like to use it in connection with the cross-examination of this witness.
Yes, the independent evaluator's report has already been received, if you'll recall.
Yes.
Last week, so we won't need to mark this as an exhibit. We can just refer to the
That's
page,
fine.
and I think that's what you were planning.
Yes.
You may approach.
Thank you.
Can we get
There,
Robert,
yeah,
multiple-
can you just hand those out to anybody that might want a copy? It's just single page.
What page did you say we were on?
Page 41 of the EI report.
There's Mr. Moore. This here's Dave.
Now, again, just for convenience in connection with the cross-examination, I've highlighted 2 paragraphs on that page. I'd like you to read those 2
Mr.
paragraphs.
Snar, just wait just a moment, please. I'd like the court reporter to get a copy of it.
Okay.
Okay, everybody has a copy in front of them now. I think you can proceed.
Thank you. I'd like you to read the 2 paragraphs that are highlighted on this particular page.
At the time of this report's publication, RMP has not yet released an RSE analysis for the mitigation programs in its 2023 through 2025 WMP. Even though RMP has stated that the RSE analysis would be implemented by the end of 2024, as per figure 23 in the WMP, it has not done so. Additionally, RMP has not provided the inputs or methodology it will use for its eventual RSE analysis. RMP has stated, however, it now anticipates the RSE analysis to be produced in 2025. Would you like me to read the second one?
Yes, please.
So as long as RMP fails to provide a sufficient detailed RSE or other detailed cost-benefit analysis, it would be difficult for the Utah PSC to judge and evaluate the reasonableness of RMP's expenditure and whether the investment is suitable for Utah ratepayers.
Thank you. Now, with respect to that RSE analysis and its evolution, is it fair to say that it was not included in the revised 2023 plan?
So I would add the clarification that's taken out of context for the section that it's in the WMP. The RSE shows up in continuous improvement, and it notes that it would take input from other parties or as it sees it evolve, and that timeline may change. What is being referenced is the figure of a potential timeframe, which shows potential implementation in 2024. We clarified multiple times, as well as outlined in the preceding section in there, that time frame would change. And as I've already noted, in other jurisdictions, we've already seen the RSC's use evolve and change in how it's being applied. And so, correct, we did not introduce it within this cycle because we did not think that was appropriate, given it is changing and evolving in the other jurisdictions that we also serve.
Now, to the extent that the paragraphs that we've referenced indicate some lack of evidence as far as the independent evaluator was concerned, were you able to provide a response to that lack of evidence finding, if I can call it that, in your filed testimony in response to the plan?
I did.
And did it include a completed RSE analysis?
It did not complete an RSC analysis, but it responded to the component of balancing the cost of implementing a wildfire mitigation plan with the risk of a wildland fire. There is no.
How did you determine the costs of the?
If I might, he was in the middle of still finishing a thing. I'd like
Yeah,
him to be able to
I'm
finish.
sorry.
Yeah, let's, Mr. Snard and Mr. Jones, let's make sure we let the question be asked and the answer given completely before we
Sure.
move on. So that's just a matter, we just need to be reminded of that. That's not a problem. But go ahead and finish your answer, Mr. Jones.
So placing the RSC within the wildfire mitigation plan, I want to add some context on why it's in there. It's in the continuous improvement section because we wanted to be transparent on what is evolving in other jurisdictions that we serve, how we actively participate in other jurisdictions and the potential evolution of a risk and efficiency analysis. Again, it's noted in there that it's used for alternatives analysis, not to evaluate the plan in a comprehensive nature. We noted in there that the timeline potentially would change based on those other jurisdictions, which we're actively participating. when we were developing the wildfire mitigation plan, we wanted to make that transparent on where it was in the industry. But we were not able, and nor did we think it was reasonable to use it here, given that we actively participate in other jurisdictions where its use is changing. Not only that, there is not a specified requirement within Utah code that says we have to do an analysis of this nature.
Bear with me for a minute. I'd like you now to look at page 6 of your Phase 3 rebuttal testimony.
Page 6 of the rebuttal,
Yes.
I'm there.
I'd like to direct you to lines 117 through 121.
I am there.
Isn't it true that the mitigation projects were evaluated and selected, quote, through the company's capital governance process, unquote, which, quote, evaluates the purpose and necessity of each and every capital project?
That is correct, and that was the documents I was referring to earlier, our investment appraisal documents, which were provided to the IE and in data requests.
What type of analysis do you employ to figure out the dollar consequences of a fire that might apply to one of these areas you're going to put a project in place on?
There is not a requirement for calculating the consequence cost. We go through and look at, for the selection of the project, the potential for a wildland fire to exist. I previously walked through that there are two elements that we do for that risk analysis. The first one is we look at the potential for a wind-driven fire. The second is we look for a potential for a fuel-driven fire to exist and lead to a catastrophic fire. We associate that not in a cost perspective, but we look at the consequence based on acres burned, structures lost, and potential loss of life. And those are the outputs of the risk model. So the analysis looks at what is the potential for a risk to exist and what is the consequence of that risk based on those elements of the inputs and outputs, but not established as cost as you asked the question. The second piece of this is going through that detailed scoping and design process, where we select the appropriate mitigation to address the risk potential that was modeled.
Okay, my question is, if I have mitigation measures, and we're going to spend $5 million on mitigation measures,
Yep.
do you ever reduce the consequences you're trying to avoid to say it's $5 million, it's equal, or it's only $3 million, maybe we ought to spend our money elsewhere, or it's $10 million that we're going to be able to avoid in consequences, this is a done deal, we ought to go for it?
Yeah, and so previously I clarified, we only select the top 15% of that risk because it has the potential for a catastrophic fire to occur. The selection, what you're referring to is alternatives analysis, and yes, we do evaluate, should this be done with covered conductor, should this be done with undergrounding? Typically, and we very rarely use undergrounding as the recommended mitigation, we determine that covered conductor is the appropriate for distribution. If that answers what you were asking.
Thank you. I have a data request response I'd like to use in connection with the next cross-examination. And I believe this comes from the data request that we're submitting in evidence with one of our witnesses, but it has not been submitted yet.
I think it would be appropriate to submit it as an exhibit at this time then.
Okay? And I'm not sure what our number is, but could we,
I thought we, I don't know the answer to that either.
While that's being passed around, can I clarify what you mean? Are you saying that this is an exhibit to someone else's testimony,
yes.
but that just hasn't come on the stand yet?
Yeah, I believe Mr. Alvarez has a package of OCS, the data request responses to OCS questions.
I mean, I guess we could not admit it separately, but I think it'll be more convenient if we have this as a standalone exhibit so that we could,
Let's identify it as OCS Exhibit 10.
sounds good to me. Okay, once folks have an opportunity to look at it, let's see if there's an objection. Mr. Moskin.
I'll represent that this is a data request that OCS asked of Rocky Mountain, and it contains the response that we received. And it's probably self-explanatory in terms of the questions and the answers there, and I'm just going to zero in on one of the highlighted answers.
Yeah, the one highlighted answer at the
Yes.
bottom of the page. Okay, Mr. Moskin.
The question we just have is where it was attached, meaning if, the parties pre-filed their cross exhibits, but there's also an indication if there's something else in the record, that's fair game. And so we're just trying to figure out where this is. I think you said it's an exhibit to Alvarez's testimony. Is it
So it will
direct
become
rebuttal?
part of the record.
Can we identify with any more specificity for Mr. Moskin as to where?
Sure.
to Mr. Alvarez's testimony.
All right, let's get clarification on it. Maybe another witness.
I'm sorry. It's,
To Stevens either.
it's,
It's not in the docket. We don't have it.
give me a moment, because I thought it was in the docket. I'll just figure out whether it's in or whether we need to admit it.
Okay. All right, we'll go off the record for just a second. You can talk among yourselves.
What number?
It's for.
Advance is the issue is surprise. I thought it had to be 2 days in advance, but maybe we can now resolve that. If we think we've resolved that, can you lay more foundation as to this proposed cross exhibit 10?
I've been told that it's a part of OCS Exhibit 7D.1-7D.7. And that is 244 pages, which are largely just a package of the responses that we received at OCS from Rocky Mountain. So we intend to submit that as, move it into evidence in connection with Mr. Dennis Stevens later today, if we get to him, or tomorrow.
Okay,
So that's where it comes from.
all right. Okay, Mr. Moskin, do you have any other response to that?
No, we probably only glanced through 243 of the 244 pages.
I understand that, and if you'd like to take a break to look through it, and I don't want there to be an argument that was of surprise here. I think it is in the record,
Yeah,
so I think it will be admitted, but if you need some time to look it over, we'll give you that time.
No, I would say let's proceed.
All right,
Thank you.
Mr. Snar, go forward.
Thank you. Mr. Jones, questions have been asked to the extent to which Rocky Mountain looks at and relies upon its own history of the probability of fault, probability of ignition, and other consequences in developing its modeling. I'd like you just to read the highlighted portion of the answer here.
Sure. Just the section or the entire paragraph?
The highlighted section in your response 4.2C, the highlighted portion.
Okay, because it continues on beyond that with additional context.
You can add
But I'll
that
read
if you
just the
wish.
highlighted section. Historical RMP data, including outage and fire incident data, are used as inputs for validation of forward-looking risk model results, not direct calculations of probability of fault, probability of ignition, or wildfire consequence. That is the highlighted section. It does follow.
And I'll just note before you continue, Mr. Snar, as I understand it, the full subsection C answer continues on the back side of the page. So
That's right.
it's not a partial submission of a response to the data request. The entire response is in this document.
That is correct.
Okay, thank you.
Do you want me to read the entire response?
I'll leave that up to Mr. Snar if
It's not required right now.
Okay.
if in answering the question you need to refer to it, then you're certainly free to do so.
He's answered the question.
Yeah, I'm not sure what.
Is
where
there a
it's going.
question, another question pending on this?
I'm reviewing my questions. Thank you.
Okay, please, thank you. I'm sorry didn't mean to imply that you should rush along. Take your time.
I may have to.
Well, you can continue after the lunch break, but
I
we do
think
have
I
a
can
hard
complete
stop.
my questions right now. Mr. Jones, the independent evaluation report looked at your plan thoroughly and concluded that the plan fails to demonstrate that it balances the costs of implementing the plan with the risk of a potential wildland fire. Isn't that correct?
Objection misstates the report. The report speaks for itself.
All right. I'll submit that. With respect to the requirements of the plan, you agree with me that the company bears the burden of proof to demonstrate that it's entitled to the rate treatment that relates to the plan and the balancing account?
Same ongoing objection regarding legal conclusions.
All right, you can answer the question as a layman, if you can answer it, but you're not calling for a legal conclusion, are you, Mr. Snar?
No, I'm not.
Okay, can you answer the question?
I can. So the plan addresses all the required elements within Utah code as concluded by the independent evaluator. The revised 2023 plan was responsive to the input from the Utah Division of Forestry, Fire, and State Lands to represent the growing wildfire risk within those pieces. The plan addresses, as my testimony, rebuttal, and surrebuttal outlines, that we have met and balanced the two elements within that contested component within the Utah code.
Now, in your witness summary that you presented today, in about the first paragraph or two, you referenced to something that was not possible. I'd like you to find that in your witness summary.
Okay.
I'd like you to read that sentence.
Which sentence?
The sentence that contains the phrase that something is not possible.
Just a minute, I need
It may take him a moment to go through his summary to find that.
So I assume you're referring to the third paragraph. I can read that entire component. So it's complete.
I want you to find the words "not possible," and I'd like you to read the sentence that those words are found in. Let's start there.
I found the word, it's not possible.
Can you read me the sentence?
While multiple parties in this proceeding would like to change the Utah Code 5424-201 to require the company to summarize wildfire mitigation, a very complex and constantly evolving risk, down into a simple cost-benefit analysis, that is not possible, nor is it consistent with how plans are developed and executed within the wildfire mitigation community.
Isn't it true that the statute is actually the thing that requires that balancing cost-benefit analysis?
Objection, again, calls only for a legal conclusion.
I have no further questions.
Okay, I don't need to rule on that objection then. All right, it is 1 minute to 12, and I think this is the time I'm sorry, Mr. Jones, we didn't get finished with you, but we'll have to come back now. I just, we have been going under an hour lunch scenario for the first two phases of this hearing. I did receive a note here that perhaps I'm a cruel and austere taskmaster, that an hour lunch is not sufficient. It's been tight for some folks. We're going to take an hour and a half break for lunch. The way I look at the cross-examination, we should have no problem finishing this phase of the hearing and today and tomorrow. So because it's been requested, and I don't know who requested it, other than it was a response that it's tight to get lunch in an hour. We're going to take an hour and a half lunch and resume at 1:30 p.m. We'll be in recess.
Chairman Fenn, thank you, sir. I was wondering if I could be excused for the rest of the hearing today and tomorrow. Mr. Schnarr has matters well at hand here, and given the briefing order today, plus the briefing on the recently filed petition for reconsideration, I thought I might get a jump on those.
I certainly understand your request, and your request is granted.
Thank you.
All right. Anybody else want to request to be excused? All right. Okay. Thank you. We'll be in recess until 1:30. All of council are here. The first thing I want to note is Commissioner Clark, we're going to excuse him this afternoon. He authorized me to cover this with you as we got back from lunch. A couple of days ago, Commissioner Clark's 96-year-old mother passed away. But before you get, concerned about how he's doing and whether condolences are always appropriate, obviously, but Commissioner Clark and his family actually view it as a blessing because his mother lived a good life and died basically relatively peacefully there at the end, and so he actually views it as a celebration of her life, and at this moment he's delivering remarks at a graveside service in Bountiful where his mother is being buried next to his father's grave. So he will not be here the rest of the day, but I want to assure you, and Commissioner Clark has indicated that he will listen to the recording of the hearing and be up to speed when he comes back tomorrow. Now, speaking of the recordings or the transcripts of the proceeding in Phase 3, I've been informed by Melissa Pascal that she's communicated with the 2 court reporters that have been present, and we've already indicated we would pay the sum of expediting a transcript. For your planning, in case you need those, I am informed that the first part of the Phase 3 docket on the deferred accounting order and excess liability insurance that transcript will be ready by this Friday, and that we anticipate the second part dealing with the wildfire management plan to be ready by Monday sometime, maybe close the business. But so I'd say close the business Friday, close the business Monday with respect to those expedited transcripts. So to the extent you can use them, you'll have another week or so to review and use them as you see appropriate. Okay, is there anything else we need to talk about before we go back on the record? Okay, I think we're going to be okay on the timing today with respect to, we should at least get through the Rocky Mountain Power witnesses, and I suspect Mr. Lee as well. Tomorrow, if this is accurate, we do not have a full day of hearing tomorrow based upon what we have listed here.
Chair Fenn, this is Steve Snar.
Oh, I don't even, apparently I don't know which way the sound is coming from. Yes, Mr. Snar.
In connection with your view of schedule and what's happening, I wanted to update the commission. We have decided we have no cross for witnesses McCoy and Barrett. We had initially forecasted 15 minutes for each of those witnesses, and our forecasts are all often off, but
Yeah.
we're not going to be engaging at all on either one of them.
Okay, well, that means we should get done. I assume the division has a little bit of cross, perhaps? No? Yes?
A very little bit.
Okay, that can vary according to what I've seen from 1 minute to 30. So we'll take that as it's been represented, and you may have some cross as well. But we'll just face that issue. But that'll shorten our day, and I'm going to hold us to the schedule here because I think it will be helpful if we end after Mr. Lee gives his testimony. We'll do the other 6 witnesses tomorrow because the cross-examination is anticipated to be about 40 minutes. So we should get through and probably be out of here before 4 o'clock tomorrow. Okay, having listened to all that, you come back to the stand, and didn't want you to have to sit there while we went through all of that.
While Mr. Jones is returning, I'm simply going to remind the chair, as mentioned earlier this morning, after Mr. Jones concludes, Mr. Dallas and I are going to be leaving. I'm not going to re-ask and call more attention, but I'm just making sure that the chair recalls we're going to do that switch at that time.
Okay, I guess that means that I don't get to give my tribute to you and your excellent job as an advocate as you leave. You'll just.
We reserve some time for that. So.
Okay. Well, I'll consider that, but otherwise you may just slip out in an unobtrusive manner.
All right. Thank you.
Thank you for reminding me of that, though. I appreciate that. Okay, Mr. Jones, you're still under oath, and we'll continue with cross-examination. Mr. Schnarr, I think you're finished?
Yes.
Okay. Any questions from the folks from the forestry?
No, sir.
I didn't think so. Okay. Mr. Russell.
I do have what I hope to be a very short set of questions. I had asked Ms. Stewart a similar question to the one I'm going to try to frame for you now. You're aware that the commission issued an order in a previous iteration of this docket, or a prior docket that's been consolidated into this one, indicating that it didn't feel it had sufficient record evidence to approve the plan on this, because it didn't have sufficient record evidence to determine whether the plan appropriately balances costs and risks. Does that sound familiar to you? Yes, it does. Okay. And my question to you, I hope, is a simple one, but it is, what record evidence has the company provided since the issuance of that order that might change the commission's thinking on that? What additional evidence has the company? I'm not asking at the IE or the Forest Service, but the company's evidence.
Yeah. So contained within, well, first of all, just clarification, the revised 2023 plan was directly Good? Yeah. The 2023 revised plan was responsive to some of the items that were identified by the Utah Division of Forestry, Fire, and State Lands of the growing wildfire risk within the state of Utah. And you'll see the growth in the defined FHCA area between the original 2023 plan and the 2023 revised plan. I would note that some of the specific callouts there were that we used outdated data in determination of that risk model, which was an appropriate callout. And the revised 2023 plan built upon not only the 2020 plan and the 2023 original plan, but updated that data set to look at those two components of wildfire risk. The potential for a wildland fire to be started from a wind-driven or fuel-driven. So maybe specifically to ask your question, what has changed, since the 2020 order approving it, lessons learned, and those? Sorry.
I think we may be talking past each other, but the question I asked was about the commission's order in this docket, this consolidated docket, indicating that the 2023 revised plan, issuing a ruling on the 2023 revised plan, indicating that it didn't have sufficient information to make a determination about the balance of cost and risk, rather than the 2020 docket or the 2020 plan, or even the first 2023 plan. Okay.
Understand now. So in addition to just supplying that revised 2023 plan, we provided a number of data requests which provided additional analysis, direct testimony, rebuttal testimony, rebuttal testimony, clarifies additional positions on that, how that determination can be made, and that additional information with referenced material. And I would highlight that the IE's conclusion isn't just a review of the 2023 revised plan independent of our participation. We were required to actively participate in that IE review, and we supplied numerous documents as well as responses to support the conclusions that the IE had. So I would still reference that the IE report has elements that we supplied in reference to this docket.
Okay, that's all I have. Thank you.
Ms. Hayes, do you have any questions?
I do not.
Okay, let's go back to Mr. Moskin for redirect.
Thank you, Mr. Chair. Mr. Jones, do you have up there this document that was the OCS Cross Exhibit 10? It was the data request with the portion of the answer highlighted, and we went through the exercise of whether you should or shouldn't read the rest of it. Do you have that document?
I do. It's OCS data request 40.2.
Correct. The OCS had you read the first half of that answer. Would you first read into the record the second half of the answer that you were not given the chance to put on the record earlier?
So beyond the highlighted section, the additional pieces is, this is required to assess the future long-term risk of utility-caused wildfire ignitions. Historical fire incidents and risk events information is useful for validation of the model outputs because modeling long-term fire risk requires projections of conditions and model parameters to understand where wildfire risks exist today and in the future, not only where it exists, when and where historical fire events occurred in the past. For example, RMP may have limited record of wildfire ignitions related to vegetation contact with bare conductor. The absence of those records, or the absence of records of these incidents do not mean that the risks do not exist today or could not exist in the future, thus requiring modeling to understand what type of risk exists where.
Okay, and why is that portion of the answer important to provide context to the portion that you were asked to read?
Yeah, it's important in how the data set is used. So the question is, how is it used within the inputs, which was the highlighted section? And the piece, whenever you're looking at developing a wildfire risk model, you want to take things that are comprehensive within the industry and not just limit it to specific data sets or only occurrences that have occurred. And so you use that comprehensive data set broadly within the industry, and you calibrate that by looking at the output with actual events. And so that's what the follow-on section goes on to clarify, is that we do use the data sets, but primarily to calibrate the model, not to use as direct inputs to the model, because it's not purely deterministic that that would be where the next fire would occur, and it's not typical that the fire reemerges in the same location.
All right. I want to turn your attention now. I'm following slightly from the question that the UAE just posed to you a moment ago. Let's start at this point. The company's 2020 plan, you indicated in your testimony that you were involved in the process of drafting that plan. Is that correct?
That is correct.
And is it your understanding that that plan was approved by this commission based upon the same statute that we've been discussing today?
That is correct, and the statute has not changed.
What information or analysis is in the 2023 plan that goes above and beyond the information or analysis that was in the 2020 plan that was approved?
Yeah. So I'm going to talk through it in two parts. I'm going to talk about the evolution to the 2023 original plan and then the evolution to the revised 2023 plan. When we developed the original 2020 plan, we were looking at what was available with the industry. You hadn't seen as many catastrophic fires occur, so this would have been in the 2019 timeframe, as you see now. They were typically, you would see them in California, you didn't see them occurring in other jurisdictions. And the mitigations of those were specific to just a few mitigations. And so the risk model at that time was appropriate to look at kind of where are your highest risk areas, determine a model, and use common practices that were available in the industry. When we advanced to the 2023 original plan, that risk model has been built substantially upon. So our original model was the REACTS model and some internally developed stuff, which is a consulting firm that provides risk analysis. And we moved to the industry standard which is Technosilva, recognized in almost every jurisdiction. And it builds upon the assumption of just an ignition by looking at two primary elements for a fire to occur and the potential consequence that that original risk model didn't contemplate. So additional analysis goes into it. How does that improve the selection of mitigation? It helps us select mitigation because we are now looking at modeling elements of the potential for a wind-driven or fuel-driven fire because those mitigations may be different. So the plan adds those additional elements. In addition, represented within because wildfires can occur anywhere, not just the FHCA area, we added additional operational practices, which are lower cost mitigations than just having to rebuild the line. We added things like full-time meteorology to assess the conditions. We added the ability to look at short-term risk models for the implementation of public safety power shutoffs, the application of enhanced safety settings, or de-energization policies to de-energize if a fire was moving near our assets. So there is substantial learnings from 2020 that are incorporated in the 2023 plan. Build upon that to the revised 2023 plan, it was appropriate for the Utah Division of Forestry, Fire, and State Lands to call out that those models at the time of submission weren't representative of the growing wildfire risk. And so those model inputs were updated, and that same analysis was reperformed, which did result in the growth of the FHCA area, which is more representative of what we see from the Utah Division of Forestry, Fire, and State Lands for our service territory.
Okay. And then specifically with regard to the question asked by UAE, you were asked a question of what information has been provided to the commission following their order indicating that they didn't see sufficient information in the 2023 plan. And I want to make sure I caught what you listed. I heard you list company's testimony in this proceeding, the IE report, which included information provided by the company. What sorry, it was
Data requests.
What other information has the commission received?
Yeah.
And,
So, go ahead.
well, so the thing I wanted to do is to unpack this a little bit. So for instance, the first thing you listed was testimony in this proceeding. Can you give an example? Does your testimony that you've been talking about here today have any areas in it in which you describe for the commission how it can determine whether costs and risks have been balanced?
Yes, in my rebuttal testimony and my rebuttal testimony, I walk through the balance of cost and risk of how we balance those two elements.
Okay.
Mr. Moskin, do you mind if I ask to give us some lines to that? I think that would be helpful.
Could you give us the lines to that
Yeah,
reference?
let me just find it real quick.
That's a good question.
So, of my rebuttal testimony, starting on page 5, line 91, the question is, please explain how the company believes the revised plan properly balances the cost and risk. That response goes through 6 different ways that we do that, from line 92 through line 138.
Okay. Now, while you were on the stand, there were lots of questions about an RSE. And those questions seem to assume or presume that an RSE is a single thing. The company did or did not do one. And I want to explore that a little bit. Using, for example, the fact that the IE called out the PG&E RSE. Is it your understanding that the RSE that PG&E utilized is the same RSE that the San Diego utility SDG&E utilized?
Yeah, so each company's RSE is different. And so the RSE proposed by the IE as a possible one, PG&E's, is different than San Diego Gas's. I would note that all of the utilities that serve in California have slightly different RSEs And it's an important item to note that the RSC is applied specifically to alternatives analysis, not to review the comprehensive plan in total. As previously noted, we're actively participating in workshops in Oregon, and we have a joint IOU session with Idaho Power and Portland General where we are reviewing what is the appropriate data elements that go into that, how is that model then calculated, what is the appropriate application of the outputs, and what should be the treatment of those outputs against the selection of either mitigation activities or how that treatment should be used.
Okay. And you indicated in response to a question that states were moving away from RSCs. Do you recall that?
I do.
Why? What information do you have to explain why states are moving away from RSC and LSCs?
Part of the reason for that guidance is that it's been recognized that the emergence of wildfire can occur, outside of just a numerical model, right? And we previously talked about when looking at mitigation, you have to look at the topography of a circuit or the orientation of a circuit. You have to look, is it near a roadway or is it traversing over the top of the mountain? You have to look at the type of vegetation that's around it. And no single model can take into account all those things as just one specific direct lookup that you can say, this is the score of the risk and this is the appropriate mitigation. It wouldn't take into account all those things. And that mitigation may not be appropriate for addressing that risk.
Thank you. That concludes my redirect.
Thank you very much, Mr. Moskin. Let's see if Commissioner Harvey has any questions he'd like to ask you, Mr. Jones.
He does. Just because it's fresh on my mind, I'd like to start with your sir rebuttal testimony on line 96.
I'm there.
Okay. Halfway across that line, I'm just going to read a little bit and then get your response to it. It says, the company, meaning Pacificor, defines RSE as the net present value of the monetized pre-mitigation expected fire risk. Am I in the wrong one?
Yeah. Did you say sir rebuttal or rebuttal?
Maybe, I'm sorry, maybe I'm at rebuttal. Let me check.
Sir rebuttal on line 96.
Oh, I'm sorry, it's direct. Phase 3 direct, I'm sorry, I
Okay.
looked at the wrong, so.
Let me just get there real quick.
Line 96 and direct, sorry.
Okay. Where it starts out on line 96 by PG&E.
On my 96, it says, yeah, by P&G, but I'm just starting in the middle there.
Okay.
The company defines RSE as the net present value of the monetized pre-mitigation expected fire risk minus the monetized post-mitigation expected fire risk divided by the NPV of the mitigation cost. The initial version of the RSC will use unitless risk reduction in the numerator, while assumptions for the monetary impact of simulated wildfires are developed, yielding a result of risk reduction per dollar spent. Is that at least close to what you wrote?
Yes, that is what is here. Yep.
All right. My background is as an economist. My actual training is called public economics, which is a study of cost benefit, how society makes decisions, and how government influences economies and societies. So it's very much on point here. I don't understand what you mean by riskless, unitless risk reduction. What is that?
Yeah. So I'm going to unpack it a little bit to just talk through the model. When we develop that composite risk score, we go through those elements that we previously discussed, the potential for a wind-driven or fuel-driven fire that results in a composite score. The mitigation then would be so let's say that comes out with a score of 0.8 as an example, or 0.85. We would then look at the mitigation effectiveness of that type of activity, and we would reduce that risk score by that component once that line has been rebuilt. And so that's what we're referring to when we talk about the unitless component of those two elements. We're taking the modeled risk score minus what is the reduced risk score based on the mitigation activity. And maybe just to touch on where we're at in that evolution is we still have a relatively small amount of mitigation activity that has occurred within the state. And so we're currently conducting effectiveness evaluation on that mitigation to say what is that appropriate risk reduction amount. Once we have that, then we would start to look at monetizing those components of it. Does that help?
Not completely. When I read that testimony, it seemed to me the monetization had to occur before any mitigation because you have a pre-monetization amount that you're using as part of the selection process. Am I reading that wrong?
So that is what the model will define it once it goes through that. The section starting on 98 with the initial version, the unitless piece, that's what I was trying to explain is how that unitless component would be defined that then would eventually add the cost components to it that is in that preceding section.
So what's the denominator in that equation?
The denominator in this section that starts on 98, the initial version of that.
Well, it just says you're defining the numerator for me. What's the denominator?
So in that first piece, we would just be looking at the risk reduction component only, and we wouldn't be defining that with a denominator.
Then it's not a numerator. You have to have a denominator and have a numerator, right?
I agree with that. That is a correct statement.
Okay. So going back to the 97 and 96 area.
Yep.
You're positing that you can come up with monetized values both pre and post mitigation.
We can, but what we are asking for is that there to be agreement in what that monetization would be of that. So, for example, if we look at the consequence of that fire, one of the outputs, the consequence is acres burned, structures lost, and potential loss of life. And so monetizing that component, we see wide variations in what is used within the industry. And so that was one of the reasons for the request for what we see consistent in other jurisdictions is to work through what should be the application of those monetization values for those outputs.
So you have not done that in your internal scoring of risk?
We have not monetized that component yet, no.
Okay. All right, I'd like to dive into the composite risk score.
Okay.
And let me just state, I've read your testimony, I've read all the testimony, and I still don't understand that score.
Okay.
So I want to understand it. And I'm going to have to set some foundation. When I received training on cost-benefit analysis, the basic formula is potential loss multiplied by the likelihood of that loss equals expected loss, potential benefit multiplied by the likelihood of that benefit equals potential or expected benefit for each time period using a discount rate to move all those values back to the present. Does that sound
Yes,
okay?
that is where the evolution of the model would go, correct?
Okay, but you, the company, not you per se, but the company hasn't done anything like that in building this composite risk score.
So we're working through that in multiple jurisdictions, because you touched on the components that go into that, right? Alignment and agreement on, are we appropriately calculating the potential for a fire to occur? And we talked about the potential for a wind-driven or fuel-driven fire to occur. The second piece is what is appropriate to use as the cost of that mitigation, and let's have some alignment on what is the cost of that mitigation. On the consequence side, we need alignment on what is appropriate to use for an acre burned or a structure lost, and should it be variable within the state, or should it be uniform within the state? So would we want to look at certain areas that properties, structures are more expensive within that piece of the model differently when we apply it to that consequence output?
All right, I appreciate that explanation, but I don't think it answered my question.
Okay.
Has the company done any of that yet?
We've done the first part, go ahead.
Sorry, has it done any of it yet in the record that the commission could see?
No.
Okay, thanks. Now, to the composite score itself, like I say, I've read the testimony, it's still not making sense to me. Give me some indication of what makes a relatively high composite number for a given fire high consequence area versus a low. What goes into that? Basically, I'm asking for a bit more detail than I got in your testimony, because it doesn't make sense to me.
Yeah. So the model takes into account where the line is serving, right? So we look at, the model is modeled on each segment of line, and a score is calculated on each segment of that line as it traverses over whatever topology it traverses over. In there, it takes into account, historical outages on that circuit, because they are potentials for an ignition source. It looks at age and condition of those assets, or conditions through our inspection that are identified on that, which would give an indication of the degradation of those assets. In that, then it assumes the potential for an ignition to occur, and looks at, if an ignition occurred, what would be the consequence of that ignition. So under a fuel-driven one, it would look at the fuels burning, and it would look at that burning, would it result in how many acres under a simulation of 8, 12, 24 hours of burn to occur. How many structures are lost? Is there a potential for loss of life given population in that area? And so those components are aggregated into a composite score that would be assigned to that segment, and each segment would have its own composite score for mitigation.
You talked about a probability of ignition as part of that process. I don't know what's causing that. I apologize for it. How do you come up with that?
So we use Technosilva's model to model that probability, taking in, and I can't speak to that level of all the elements that go into how that's calculated, but we did provide to the IE as we went through that review all the subcomponents, and then went through a meeting to show each one of those in. You got to look at it in the model itself. I know I'm not.
So when I read the testimony, it talked about two different phases of modeling. I think it was fire, I can't remember the two names, but are those what you're talking about when you're talking about Technosilva?
Correct. Fire site.
Okay. Yeah, fire site, okay. I guess I didn't see something in there that would have led me to think about the probability of ignition from your equipment. It was more towards what would happen if one occurred.
So it has both pieces of it. On the one side, it looks at the potential for basically an asset failure, degradation failure to occur. So that piece of the probability, and then you are correct. The other side of that looks at the potential for an assumed ignition. What would be the result of that ignition to occur? And where that sits within the model, I can't.
So PacifiCorp had to provide to the modelers very detailed information about the fitness of its system in terms of how likely things were to break?
Yeah, so we provide our GIS information, so the circuit, where it serves, how it serves, things like that, the orientation of that. We provide, the asset age if it's available. We provide the inspection condition or any identified conditions on those circuits. So for example, a degraded pole or a split cross arm or things that could be indications of failure on those assets.
But if Pacificor knew about things like that, they would fix them, right?
Correct. And our inspection and correction policy is enhanced under the wildfire mitigation, but we still had it existing before. It's enhanced under the correction timeframes to correct them faster or replace them with equipment. For example, fuses, replace them with non-expulsion fuses. Replace arresters, which have the potential for ignition because it fires a 22 shell to separate the electrode off the bottom, a potential ignition source, to non-expulsion arresters, things of that nature. Correct.
Okay, yeah. But in doing that, you still try to monetize the potential loss.
I ask your question again. Do we try to
In
monetize
doing
the loss?
all that modeling that you've just described over my last few questions, you're not doing the final step of saying this is the actual expected value of a loss.
Correct. We have not done that in the development of the 2023 plan. We look at the mitigation types based on the potential for that occurrence that would need to be mitigated, unmonetized,
Well, but what determines whether it needs to be mitigated?
because it has the potential for those consequence elements to occur. Acres burned, structures lost, potential loss of life as outputs. And we would want to mitigate those by reducing the likelihood of that occurring. It is heavily dependent on the Technosilva model, which is an industry recognized model for modeling these types of characteristics.
Well, I guess what I'm trying to get to, and I'm realizing I may not get there. If a mitigation project is going to cost $10 million, what makes you, you're apparently possibly the decider here, say that's worth it or not?
Gotcha. So I'm going to walk through our governance process. So all projects that are defined in, remember, we talked about the 15% of the top risk, which is...
And we'll get to that.
Okay. Which is the ones that we select for system hardening, line rebuilding as an example. That goes through a detailed governance process, and there are multiple voting members that participate on that in addition to myself. As part of that, we go through that detailed scoping to say, is this type of mitigation activity, would it address the modeled risk that is there? And then what is the associated cost? Is it inside our FHCA area, or does it serve inside or outside of the FHCA area? There are times whenever it is appropriate to go slightly outside of the FHCA area because that is electrically connected, and that is where either the protection or the same risk still occurs just slightly outside of that FHCA area. From there, then we take those projects as scoped, saying that it is appropriate for addressing the modeled risk, and we would go through a competitive tendering process to make sure that those costs are in alignment with market rates. So we don't just award, let's say somebody gives us a bid for $10 million to do 2 miles of line. That would not be in alignment with market rates, and so that's what the competitive bidding process does, is make sure that we are getting market rates for that. And we use internally some go-bys, as we refer to them, to make sure that they are in alignment with what we would expect.
Yeah, let's talk about the composite risk scores again, this ranking of them all. So the model outputs, based on these inputs that you've described to me, kick out some type of a score. And
Correct. on each segment.
For each segment of each line within, excuse me, the Utah territory.
That is correct.
All right. And then you've just numerically ranked them, apparently.
So we look at that circuit, so we aggregate the composite scores for each segment under a circuit, because it is typical to see that same condition exist across the circuit. Now, there are variations to that, but it's typical to see that circuit is, because it's serving in the same area, usually has the same kind of vegetation concerns, relatively matches that. And yes, we would then rank those, addressing the highest risk first and working our way down.
Okay, and so my question is, if we haven't monetized anything, what's the actual meaning of saying something is the highest risk area, other than it has a slightly higher number than whatever's in place number 2?
Yeah, because it has the potential for loss in acres burned, structures lost, or potential loss of life.
Okay. I guess I'm trying to get at is there any inherent meaning to that score? And let me just give a bit of background. When we talk about number theory, we talk about 4 classes of numbers. And as you move up the classes, they acquire more and more meaning. And the first one is just simply categorical. You can assign, say, if people's eye color is blue, they're a 1. If it's brown, it's a 2. You know, however many you want to do. There's no inherent numerical meaning to that. It's just a category, right?
Correct, but we see that it's common use within everybody that models wildfire risk.
Okay. And as we're moving up this scale, this numeric scale, we get ordinal, and I think this is where PacifiCorp is at on this, where you say there's no absolute meaning to these numbers, but we're ranking them based on that number. Okay.
I'm going to trust you on
All right.
Yep, your definition.
You eventually get to something like, say, a temperature, where there is a fixed unit for each degree. It means something,
Correct.
but 0 doesn't mean that it doesn't exist. It's just a marker. And then the final gold standard for a number is where 0 actually means 0, and the numbers have what we think of as numbers. And I would submit, and I'm asking your opinion if you agree, that this composite score is just an ordinal number. It doesn't have any inherent meaning. Does that make sense to you or not?
It does, but I would add that we look and learn from other utilities that model this risk and have experienced that loss. And we see that model appropriately looks at that long-term risk whenever we look at it in other jurisdictions, right? And so we don't want to wait for the occurrence of that big catastrophic fire to occur in the state of Utah to be able to say that the model that is recognized in other jurisdictions, that has been calibrated in other jurisdictions, is reasonable to apply here.
Okay. So why 15%? Why the top, actually not percentile, the 15th percentile, why is that the cutoff for where you worry about stuff?
I will say it is looking at kind of trying to establish the first balance. So I'm actually gonna go back to the 2020 plan when we were developing it. We looked at the time frame to implement mitigations at each level. And when we looked at how much work could occur each year based on resources availability, material and things, that was one of the constraints. And so how long would that risk be? How much would that potential cost to do the mitigation? So not the cost of the loss, but the cost to do that mitigation. And where would that be as far as how long that risk could occur? And so there was, when we go back to 2020, there was a discussion that try to address things within that 7 to 8 year time frame, and that outlined kind of where we think this potential catastrophic fire, not just the occurrence of fire, but a catastrophic fire to occur, and it was around 15%. I will say that was a starting point, and it may be appropriate to move that up or down based on how risks evolve, or we see that the mitigation's effectiveness is used.
I'm assuming you're fairly familiar with these composite scores in terms of the database. You've worked with it a fair bit.
Correct.
If you were to plot on a graph the scores just using a regular numerical scale from the lowest to highest risk, are there groupings? Is it uniform distribution?
It's not uniform. You'll see groupings of where you know, it's driven by, you know, a lot of vegetation, potential for it to burn unsuppressed and things like that. And we kind of back validate that against, you know, what Utah Division of Forestry, Fire, and State Lands originally published whenever we looked at 2020 as well as 2023 to say, are we seeing areas that it's reasonable that these are identified as a potential to burn unsuppressed, which would lead to catastrophic. So you see a catastrophic grouping that, you know, they burn over 5,000 acres, they have over 500 structures lost, there is a potential for loss of life. And then you start moving down into a grouping where there are suppression things that can be done, but yes, it will grow unsuppressed for a while. And then at the lowest level, you'll see kind of a grouping where low vegetation, it's predominantly concrete, you know, it's like in an urban area, which fires can still occur in an urban area, as we've seen in LA, right? But it's a lower likelihood for that to occur.
So that top group you mentioned, what percentile would that be?
So that is around the 15%, where we see, you know, it's typical in the industry to see about 5,000 acres burn, 500 structures, or loss of life.
And that just happens to match 15?
It was about 15%, yeah. We were trying to create a starting point, and we've used that starting point to hold the plan, and we update the data, update the composite score, see if there's new emerging areas based on the updates. But yes, it is still typical in the industries to see it around that 15% in the Technosilva model.
Okay, and so you mentioned in your answer the potential to burn 5,000 acres, 500 structures, but you didn't mention anything about the probability of ignition. Are those areas where the probability of ignition is also high?
Yes.
And that's part of that, your
Composite
testimony is that it's part of the composite score?
Correct. It takes into account the probability of that ignition, and then this is, if an ignition occurs, what is the consequence of that ignition, right? As those outputs.
Okay.
I wish I could show the model on screen and walk through it. It'd probably help a ton.
Possibly. So you keep talking about the wind or fuel-driven effects. I guess what I'm trying to understand is whether or not PacifiCorp is essentially focusing primarily on ignition or just wildfire risk in general. Because as I'm listening to you and other witnesses, I'm hearing both.
Yeah. So I'm not a fire science expert, but what we have learned from that community is that there are two types of fires that you need to look at, right? Is the potential for a wind-driven one where it takes it and burns out of control, unsuppressed, primarily driven by wind. And so you could have lower or moderate vegetation, but you have strong winds that burn it into areas that grow catastrophically. On the other side of that is that you have lower winds, but you have a lot of fuel that can lead to a burn starting, and then that creates its own burn pattern. And so, again, not being a fire scientist, what we see from that community is that there's a recommendation to model those two elements, and I think that's consistent with what we see from the Utah Division of Forestry, Fire, and State Lands as modeling conditions in that type of science.
Yeah, I guess I'm trying to get at is I have no quibble that fires can start from all sorts of things. They can burn in all sorts of areas with all sorts of patterns. But I'm not, what I'm trying to find out is Pacificor worrying about all of that, or is it just simply saying, are we gonna start a fire?
So, we look at that consequence as one of the primary pieces to selecting where and what type of mitigation we do, right? So, we have a lot of our area, right? We talked about 85% of the territory that isn't targeted for system hardening or line rebuilding, right? In those areas, we use real-time modeling of the meteorological conditions. We look at changes in the fuel condition for those areas, and we would deploy lower cost strategies to that than rebuilding the system. And we do that for implementations of things like enhanced safety settings, which whenever we have a fault condition on the system, it has an instantaneous element that disables the system and does not try to reclose into that condition, which has resulted in ignitions within the industry. And so we look at applying those, what I'll say, bare minimum or low-cost mitigation strategies in those areas, and then we just graduate up that scale based on what is the consequence of an ignition occurring if one was to occur there.
But you're not worried about general wildfire risk. You're worried about ignition risk, or am I wrong?
We are worried about ignition risk and the potential spread of ignition.
Okay. Okay, shifting gears a bit, does Pacificor have easements wherever it has either transmission or distribution lines in Utah?
Yes, we have transmission lines in Utah.
No, do you have easements for those transmission lines and
Yes, we do.
distribution lines?
Yes.
So, and the policy, I assume, is to keep those easements clear?
Yeah, I would make items, over time, what we call a corridor or an easement width has changed. So it's dependent on voltage, which we would have a recommendation for that. And over time, you see that has varied. So some of our easements may be over a legacy easement that we have. Some of the newer ones would be wider. One of the concerns specifically we have with that is you still have the potential for what's called fall-in risk, for a tree, dead vegetation to fall into the corridor, because it would be unreasonable to widen the corridor for all fall-in risks. 110-foot tall tree widening the corridor 220, 240 feet. Do we maintain the vegetation in that corridor? We maintain it where we are allowed to maintain it, but that doesn't address this potential for fall-in risk or emergent grow-in risk. And we have inspection practices to go out and identify those conditions.
Well, yeah, you have money in your base rates to do vegetation management on I think a 3-year cycle. Does that sound familiar?
We do have it. I can't speak to the specific cycle, but that is correct.
All right. So if I'm thinking about ways Pacificor's equipment can start a fire,
Yep.
It would seem to me that the two basic ways are the equipment itself can eject something that's hot, like the .22 caliber
Correct.
thing, or expulsion fuses or something like that. We've read about that testimony. And then the other is that if the electricity comes in contact with something that's flammable.
Correct. So maybe just to walk through a couple other pieces. So starting out with just different equipment that has the potential for an ignition. We talked about fuses. The element will burn. It whips a tail out. Molten metal can come out of the bottom of that tail, can result in an ignition. It depends on wind speed, how much it cools down, height, things of that nature. And these are all validated within studies at like KEMA labs or labs within Australia or in California. Arresters have, traditional arresters have the potential, because of that, removing the electrode, it will fire an explosive device, a .22 shell, ejecting the bottom side of that electrode. You have the potential for conductor failure, so degradation in the conductor. We look for conditions like bird caging, which would show material loss of structural integrity and the potential for that wire to come down. If that wire comes down, then obviously you have energy flowing into the earth that is a potential for ignition. Pole failures, degradation at the ground line rot, and then high gusting winds or non-prevalent winds that result in the structure failing and resulting in an ignition as some additional ones. Correct.
Well, I mean, they would fit in those two broad categories, right? The system's ejecting something hot, or something breaks and allows electricity to hit, right?
That is correct. And let me add one additional to that. You can have the blow-in or fall-in risk, right, that we previously talked about. When doing vegetation management, you can have what's called hanging conditions, where a tree branch fell, so it was appropriately trimmed, but that branch dies. It's a hanger, and that branch can fall down through wind or other things into a bare conductor.
If something from outside the easement contacts your system, and this is a theoretical question, would Pacificor be liable, or would the owner of whatever it was that contacted the system be liable?
So I can't speak to it specifically on what would be the final outcome. I can tell you, I have testified where we have things like trampolines that have blown into our line, resulting in an ignition, and that ignition was identified. We were the identified cause of that ignition, not the trampoline or the trampoline owner, and we would have to go through that process to identify, what was the condition of the line, what protection was in place, things of that nature to defend that. So I can tell you, I've testified in those very situations where it was things that were not our assets, came into our assets, but we were still the identified cause. Source and origin of that cause.
Mm-hmm. Okay, interesting. All right, just checking my list here.
If you remember a couple years ago, the bountiful downsloping winds that
I do
blew
remember
into
that.
it, that was one of the trampolines. And then the large 100-year-old trees that are outside of our vegetation corridor that blew in and resulted in substantial damage. So those are very atypical winds, right?
Yes.
To that degree.
Indeed. All right. Just a couple of hopefully final questions then. In listening to you today, it seems to me, and I want you to confirm whether or not I've got this correct. It seems that you assume the balancing aspect of the statute applies after a line segment or a line in general has been selected for treatment, and that it only applies to choosing between methods of treatment. Is that correct, or am I misunderstanding what you've
I think that's one piece of it. Let me clarify. When we look at that Utah code requirement, it has two elements, and we believe we've balanced those two elements. I'll talk about the risk of a potential wildland fire through the modeling that we just discussed, selecting the appropriate mitigation, selecting that top 15% to go after for system hardening, and then using lower cost mitigation. We believe, and the IE concluded that we have appropriately modeled that risk and set that risk level appropriate, and we have a comprehensive plan to address that risk. So that's one piece that we believe we have shown a balance. On the other side of it is, once that is selected for some type of mitigation, we go through a governance process, a selection and design process. We go through confirmation through competitive bidding to make sure that it's in alignment with market rates to balance the cost of implementing a wildfire plan. So we don't look at balancing those two elements. We do balancing in each one of those elements independently.
All right, but, so just to make sure I've got it right here, you're testifying that you don't balance the two parts against each other, you do balancing within each part separately.
Correct.
Okay. You've mentioned several times that the RSE is a moving targets and your other jurisdictions are in flux, I guess you'd say. Is that a fair summary?
Correct, and that's why we noted in the 2023 plan as an area for potential continuous improvement.
Okay. Why does the company think that evaluating a Utah wildfire mitigation plan depends on any other jurisdiction's metrics or policies?
We don't think it depends on another jurisdiction's, but we do want to recognize that we learn lessons from the industry. And the IE identified California and specifically PG&E as a possible RSE to apply. When we were working through the development of RSE internally, before kind of the changes in the jurisdictions in Oregon and California, we recognize that, and I previously noted that the two people that are leading that modeling effort, one came from PG&E, the other one came from San Diego Gas, and I think it would be irresponsible to not take what they've learned. I mean, those two utilities are billions of dollars into investment. I think Southern Cal and San Diego Gas are north of $4 billion of investment into that. We would want to learn from that modeling, how that's applied, the mitigation, and the application of these models for here, so that we don't have to spend that same amount of money to learn those lessons. So I guess that would, do I think we should take California and apply it here? Absolutely not. I think we should go through a workshop to agree to the model. We want to be transparent on how we select these circuits and how we model that risk, taking input from the Utah Division of Forestry, Fire, and State Lands, as we have done. And we would welcome putting the consequence values to that. That would honestly make it much easier for us to work through evidencing this component that has been contested. So.
All right, well, that's all. Thanks, I appreciate it.
Thank you.
Okay, Mr. Jones, I hope my questioning will be not too long. I just have a couple of things for clarification. In the original 2023 plan, your FHCA's were estimated to be about 650 miles of lines. Is that your recollection?
That's correct.
And then when you worked with the Division of Forestry, Fire, and State Lands, in the revised plan, it was increased to about 2,050 miles. Does that sound accurate to you?
That sounds accurate.
I'm trying to do this
Yep.
in that, asking if it's accurate rather than taking the time to refer to everybody else's testimony. I want to expedite through this. So tell me how you've then approached the mitigation efforts since that collaboration with this the Division of Forestry and Fire and State Lands. Have you focused on the 650 miles identified in the original plan first, or does it or not so?
A large part of it is still focused on that original 650 miles. There are a couple emergent areas that have been targeted, but just based on the timeline it takes to go through the scoping, construction, permitting process, we still are working through mostly the circuits that were identified in that original 650.
Okay, so we can use whatever universe is most appropriate for you, but if we chose to focus on the 650 miles, I guess I'm trying to figure out your process of determining the mitigation efforts that are made. Do you have, let's take a distinct period of time, let's say 2024, that's pretty recent. Do you know the number of different projects that were completed in 2024?
don't recall the number of projects. that
Oh,
were going
okay,
on.
what about miles? Of how many miles was there a mitigation plan?
I know we provide those in the annual cost and compliance report, but I don't recall the exact miles.
Okay, I wouldn't hold you to it. Can you give me any estimate?
Yeah, I believe it was around 50 miles in the state of Utah. The number was 260 miles across Pacific Corp that was addressed. So I know the Pacific Corp number, I just don't have this.
Okay, and I appreciate that. I guess I'm trying to understand the process by which you make a decision whether to do undergrounding of facility, of lines, or covered conductor, or a vegetation management program. So can you give me approximately on the projects that are completed, I'm just trying to get an idea of scope.
Yeah.
How many of those miles, or percentage of those, how many of the projects you've completed would have been undergrounding of the facilities?
Yeah, undergrounding, not having the exact number, would be less than 15-20% of those. Most of them are selected for overhead covered conductor because it is a lower cost. We see it typically in about the 1.3 million a mile. We see undergrounding in the 2.5 to 3 million a mile cost range.
Yeah, significantly more.
Yeah, and maybe the Immigration Canyon would be a good example because we did select undergrounding for a portion of that.
Okay.
And to talk through why that was appropriate. So when we looked at, it had a high potential for a wildfire risk. Where the line served was just slightly off the roadway, so you had two fuel sources on either side. The first piece was looking at, could we bring that line out of that corridor along the roadway and do it with a covered conductor? We ran into challenges with permitting. We ran into challenges with construction where we would have to install a number of down guys in order to continuing to follow the road, and we were prevented from being able to remove the vegetation there. So in that case, it was more appropriate to underground that and serve that because we could go in a straight line rather than moving along the roadway by moving it out of the vegetation corridor.
Okay, did you, so let's talk about what percent of the lines and projects you've worked on in the last 24 and 25 to date. How many of them did you choose vegetation management as the course of mitigation?
So in the area that we target for line rebuilding, vegetation management would have been a component, but outside of that area, then almost all the area is targeted for vegetation management.
So you're talking about areas that are outside the fire high consequence areas, is that correct?
Let me clarify. Inside the fire high consequence area, we have enhanced vegetation, and we're doing that because the risk is still there and the potential's still there, but it is going to be a while before we can rebuild the line. So yes, we would have enhanced vegetation applied to that to reduce the risk of grow-in risk, fall-in risk, hanger conditions, things of that nature.
Are you still then planning on doing covered conductor or undergrounding in that, on that particular circuit?
It may be towards the back end of the plan if it's in that 15% where it still could result in a catastrophic fire. But that's one of the reasons why we update the model annually to see, does the conditions change? Is there something that reemerges there? So,
Can I ask you what you are doing for enhanced vegetation management? You have a typical cycle that you follow regularly that's in rate base for vegetation management throughout the state, and I understand it's on a 3-year cycle. So talk to me about what incremental level of vegetation management you undertake in a FHCA.
Sure, and I'll defer a little bit to Mr. Barrett that oversees that program.
I
that
can,
could give
I
you-
can ask him instead,
Yeah.
if that would be more
He
appropriate.
can give you some of the specifics
Okay,
that we do on that.
I'm trying to not prolong your stay on the stand. I'll ask Mr. Barrett that.
Okay.
I'm trying to understand when you make a decision about choosing between or among three methods of undergrounding, covered conductor, or some lesser form, and then vegetation management. Are you making a decision in part based upon the your analysis of the reduction in the risk of a wildfire based upon using one of those three methods?
We don't use that as much to determine what is the appropriate mitigation. We look at the conditions that lead to the likelihood of a wildfire burning and burning uncontrolled, and then selecting the mitigation. I will say, we start out with covered conductor, where it's targeted for line rebuild, looking at the conditions of those assets, what is the condition of the poles, things of that nature, how does it serve. I would note that, application of like enhanced safety settings, so that's the protection and control piece of it, to reduce a potential ignition from occurring. We would apply that broadly across not just our FHCA area, but outside our FHCA area where we see that emerging. The one downside of that is it results in more outages. It results in a degradation in performance. And we've seen that within our SAIDI and safety statistics, a degradation in performance in those areas. And so one of the ways to reduce the experienced degradation in performance is to rebuild those with removing the conditions that lead to that outage.
So in an FHCA, is your objective ultimately to rebuild all of the lines that are in that FHCA?
They would be targeted for that, but I don't think it's reasonable. It would lead to extreme rate pressure, cost. We need to continue to monitor what the industry's doing and find a solution for that through better protection and control, other things like that. We're trying to be very transparent on how we address those risks that come forward. Yes, if nothing emerges to address wildfire risk in those, given that it could result in a catastrophic fire, then yes, we would be looking at line rebuilding. But we would try to avoid rebuilding the entire FHCA area, or recognizing that leads to extreme rate pressure.
So just for an example, in Salt Lake County, is it one FHCA or are there multiple FHCAs within Salt Lake County?
So it is one, we designate one FHCA area. It is got some segmentation to it so that we can apply operational practices to it, but it is shown as one area, and you'll see it move in and out of certain neighborhoods and stuff like that.
Okay, so essentially, generally, Salt Lake County is one FHCA. There may be some gerrymandering of lines.
Yeah, so if you look along the benches, you would have the FHCA area along the benches. And so you would have circuits serving up to it, and then we would only identify those segments of the circuit serving into the FHCA area as subject to this line rebuild, not the entire line going down into the neighborhoods that don't have that same profile.
And that's because you evaluate a greater risk at the urban wildland interface, correct?
Absolutely.
Okay. So not all circuits within an FHCA are treated the same by Rocky Mountain Power. You do a risk analysis within the FHCA, and so I'm just trying to figure out whether how we know what lines, I mean, I don't see the granularity in the report to know what number of miles within an FHCA are going to be rebuilt, or whether there's gonna be vegetation management as the preferred, or at least the method you're gonna settle on. Is that?
So that's an important distinction, right, is we will have some circuits that are completely in the FHCA area,
Right.
and we'll have some circuits that serve into and out of the FHCA area. For the ones that are completely in the FHCA area, we would be looking at kind of what is the segment scores change over that entire circuit, and potentially prioritize some of that for, you know, a phase 1 or phase 2, but the whole thing would look at it. Outside where it serves in and out of the FHCA area, we would not apply line rebuilding to that area outside of the FHCA area unless it's this short piece that's electrically connected, because, I mean, the system doesn't recognize an arbitrary boundary for the potential there. We would go to the protection device that serves in or out of it, electrically connected.
So if the circuit is in and out of the FHCA, you would perform an evaluation as to whether you would complete the entire circuit or not. Let's say you decided to complete the entire circuit, would the part outside the FHCA be included in the wildfire mitigation costs?
So it would not be, and to clarify, those require going through an internal governance process. Any line segments identified outside the FHCA have to go through this review and voting member of why are you identifying areas outside of the FHCA area for line rebuilding? And that definition of electrically connected may be the appropriate one. Or does it have some other risk that doesn't show up in the model? And then that would be part of that governance process. If it's outside the FHCA area, then it would, and we chose to do line rebuilding, we typically identify that as betterment or outside of the wildfire mitigation activity.
And that's categorized in another cost
Correct.
category, and tracking that, not through the wildfire mitigation plan.
That is correct.
What if the lines are at the urban wildland interface in the FHCA, and you've got the circuit continuing in the FHCA but as a lower risk area? If you decided to then rebuild that entire line because the other parts, I mean, I could try to come up with an example, but you get what I'm saying. Would you then, where you have a determined lesser risk in the part that's not still in the FHCA, but not, let's say, at a high risk urban wildland interface, the entire circuit would then be in the costs in the wildfire mitigation plan. Is that correct?
No, so let's say you have the wildland urban interface and then you have the FHCA area, so low risk, wildland urban interface, FHCA boundary, high risk. If it's in this section between the wildland urban interface and the FHCA area, our governance process would stop at selecting line rebuilding at the FHCA boundary or the electrically connected. It would not go all the way to the wildland urban interface. Now, we do see it's common that the wildland urban interface is very close to or nearly exactly the same as the FHCA boundary, given that you see burn-in risk to obviously population, or you see the potential for it to burn out of that.
Yeah, I'm talking about whether the urban wildland interface is part of the FHCA, and then you've got another part of the FHCA, but not all circuits within an FHCA have the same risk profile.
That
you
is
agree that, right?
Correct.
But would you then, if it's in an FHCA, do you feel like it's then legitimate to have the cost of a rebuild or other mitigation efforts included in your wildland fire mitigation plan?
If it's in the FHCA,
If it's
yes.
in the FHCA?
Correct.
Okay, all right, thank you. So I guess I'm trying to understand the cost information that has been provided to the commission. And I want to just take and just revisit the question Mr. Schnarr and Mr. Russell asked. So I want to make sure we're talking not apples and oranges here, and that is, it's not an issue from the original plan on the revised plan. The revised plan came out in February of 2024, as I understand it.
That is correct.
Okay, what I'm talking about is the June 27th, 25 order for additional time and process, where the commission said, 24, excuse me, June 27th, 2024, I'm drawing.
Going into the future, I like it.
Yeah, I'm going into the future, or either that or I'm tired. It was the order for additional time and process.
Right.
And I'll represent that this is what was stated. On the record before us, the PSC simply cannot find the revised plan appropriately balances the cost of implementing the plan with the risk of potential wildland fires. Okay, so that was in June, and then you had the January 10th IE report, where they made basically that Charles Rivers Associates made the same conclusion.
I have a slightly different view on the Charles River IE summary. Maybe I can just reference it. They found the cost to be compliant. So let me just get there real quick. Because I think it's an important note. I think part of your question is, what did we do with the June order? We actively participated in the independent evaluator. We see that is common in the industry. We do it in other jurisdictions as well.
Yeah.
The couple key, I guess, pieces as we take a look at it. I mean, in the executive summary, they identified that RMP properly assessed the wildfire risk. CRA believes RMP's risk assessment methodologies and maps generally comport with industry standards, practice, and alignment with public available risk maps with the state of Utah, and then it goes on to reference a couple other. The second part is the RMP sets forth a significant and comprehensive program to address the identified risks and compliance with thresholds set forth in Utah Code 5424-201. And then this next piece, and I'll make note of, it's in section 3, about halfway down. Puts forward cost information sufficient to comply with 5424-201. And so we were, between June and the January report, we were trying to provide that information, the investment appraisal documents, the documentation of all the projects, workshops to go through and review how the modeling is actually done. And we view that it says that the information is sufficient to comply with the requirement. It does go on to say that the cost information is not sufficiently granular, which we can provide more granularity.
Yeah, no, I appreciate that, and I think you accurately stated what the IE found with respect to compliance with a number of the provisions that are in the statute and the rule. And I grant you that. My concern is more about the issue that's on page 41 of the report. So let me read it as the last, you have that in front of you, I think it was used before. It's this paragraph right before 5.1. So long as RMP fails to provide a sufficiently detailed RSE or other detailed cost-benefit analysis, it would be difficult for the Utah PSC to judge and evaluate the reasonableness of RMP's expenditures and whether the investment is suitable for Utah ratepayers. So I understand from what you've testified about the difficulty and that the RSE is a work in progress.
Okay.
But what my question is, was there any cost-benefit analysis by which the commission could make a determination that for this circuit, the three options that are out there, one that costs a couple of $1 million per mile, $2.5 to $3 million per mile undergrounding, and another one, there's some debate about how much covered conductor, the office's witnesses say it's lower, but be that as it may, you're saying that covered conductor typically costs,
1.3.
yeah, 1.3 million.
Yep.
Well, so what does your current enhanced, well, just your current vegetation management program cost you per mile?
Yeah, I defer to Alan on that.
Okay,
or
so,
Mr. Barrett.
so I have some information that's, and I don't purport to know whether this is accurate or not. This is what the this would be what Mr. Alvarez claims, that the cost was approximately $3,200 and something per mile. That seemed within the range of reasonableness.
Yeah, costs have gone up. We see that in two components. The material cost has gone up, primarily through COVID. We've seen the cost of this type of material. It was a scarcity, cost went up. Labor costs have also gone up. And so that is a large part of why you see increases for this type of mitigation. That's consistent with what we see in the industry.
Yeah. If you enhanced your vegetation management program, I don't know, maybe you do use these things now, but let me just throw out, in an FHCA, a vegetation management, let's say you use drones. Are you using drones now?
So we do use drones, but there's a limitation. So there are certain utilities that are allowed to fly beyond line of sight.
Right.
We are restricted. We don't have a beyond line of sight ability. And so it is more costly to be able to go set up, fly within line of sight, go and set up again. So our drone program does have some restrictions, but
You'd have to get a law change to be able to go beyond line of sight?
we have to get a licensing precision from the
to do
FAA.
that.
Yeah.
Okay, how often in a year in a FHCA do you do a vegetation management visual inspection by driving along the right of way?
I believe it's annually, but I'll defer to Alan. I believe it's annually.
Okay, all right, so I guess some of these questions should be asked for him.
Yeah.
So I guess my question is, the cost of any of these three alternatives, are we talking about the impact to your customers, ratepayers, by the choice of which alternative you use? The costs are not, you don't anticipate the costs will be borne by the company or the shareholders, right? You anticipate those costs will be borne by the ratepayers?
The cost of the mitigation would be borne by the ratepayers, that's correct.
Okay, so whether you choose a $3 million per mile, a $1.2 million a mile, or let's say enhanced mitigations, if you used all the enhanced mitigation techniques you could, that would be, let's say 10,000, I don't have any idea, I'm just throwing it out for illustrative purposes. I don't see anywhere in the record where the commission can evaluate the three choices with respect to the risk mitigation impact from a percentage reduction in risk or cost, a dollar estimate. It hasn't been monetized, as you would say, correct?
Yeah, and agree, I don't know if it shows up in record. That was part of what we thought we were working through with the independent evaluator.
Yeah.
Is to provide that information of, give me, projects that are covered conductor why was that selected? What was the governance process in that selection, which we went through?
Yeah.
I would note that vegetation management, enhanced vegetation management doesn't always address the risk, right? You can have fast growth cycles because of, water that is, abnormal for that growing season, and that vegetation can grow back in. And so we can't solely rely on just vegetation management with bare conductor if we have that potential for a catastrophic fire, because you have to have near 100% accuracy on identifying it and going out and doing repeat inspections where you have late water periods that lead to fast growth and then a quick die off of that vegetation that leads to an enhanced vegetation fuel-driven risk.
I appreciate what you're telling me on that. Would the fact that you are building meteorological facilities throughout the state give you information about that?
Correct.
So you could, it's just a question of how aggressive you want to enhance your vegetation management, is whether you could mitigate that risk by that.
So some of the things that we do look into is, did we have out-of-cycle growth occur? Have we had vegetation contact even with the specified trim back parameters? And those ones we would want to do covered conductor, because you can't increase the frequency fast enough to always mitigate that type of risk where you see that reoccurrence.
Okay, I appreciate that. Just a couple of final questions. I think you stated in your testimony that another concern with respect to the vegetation management program is that your analysis is, if you do covered conductor or undergrounding, that typically is a one-time cost.
Correct.
Can you give me any example where that would be atypical, where you would spend additional money if you chose that option of undergrounding or covered conductor, where you would incur additional costs down the road?
Yeah, so there's a significant reduction in the, once a line's rebuilt with overhead, covered conductor or undergrounding, a reduction in that vegetation management cost once completely constructed. A couple areas where you could still see vegetation. So let's use the covered conductor as the first example, where you have the potential for canopy growth over the top. And we talked about that hanging condition where tree branches could fall, still tearing down the structure. We would still want to mitigate from that, even though the conductor is covered, and even though it lowers the risk, that type of failure and pulling that conductor to the ground still is a risk that needs to be mitigated. So we would still have reduced, but we would still have some vegetation management.
You still have the risk if it was bare conductor too.
You have a
It'd be
much
higher risk.
Much higher risk.
Okay.
Correct.
All right.
On undergrounding, it's small, but like so your underground conductor comes overhead in what's called pad-mounted equipment. And in that pad-mounted equipment, you can have vegetation grow up inside of it, and you use herbicides and other things to eliminate that growing in. We have had fires start or ignite even on underground equipment, and so there would still be a small amount of vegetation management to prevent that growth of vegetation inside of these cabinets where the underground comes overhead and then goes back underground again. But it's much less than your traditional bare.
Yeah, so I think you then go on to say that basically because it's a one-time cost versus the cost that has to be repeated on a regular basis by vegetation management, that's another reason to choose the at least initially more expensive options.
Correct, and I would also add to that, and we talked about it, is we have a concern about, even once you do the mitigation, of fire still to occur, and so you would look at eliminating where there still is that condition, right? The hanging canopy risk, things of that nature.
So just I want you to respond to Mr. Alvarez's rebuttal on the analysis on the one-time cost versus the reason that you would choose that because it's a one-time cost is, his argument is that you could have, essentially at present value, you could have over 41 years, the cost of a $6,000 vegetation management program per circuit mile, repeated every 4 years. And I grant you, I think you'd repeat it more often than that. But if assuming his analogy or his illustration, that would amount to just $22,306 per mile in the present value. Does that seem within the zone of reasonableness?
Yeah. I haven't done the calculation, but it sounds reasonable.
Yeah,
I would say, though, that it's important to note that we don't select the mitigation just, solely based on cost, right? Back to the piece that there is a concern where you have repeat activity, that you have the repeat possibility of whatever that you're trying to mitigate, vegetation management, things of that nature. And one of the pieces we are trying to address is to reduce that potential is there. Bear conductor is a real risk.
right. And I appreciate that. Just finally, I guess I asked the question, maybe you don't see this as a concern for the commission, but I look at the testimony provided since we issued that order in June, direct rebuttal and surrebuttal, and I'm still struggling with a cost-benefit analysis so that there's a quantifiable understanding of the mitigation dollar amount when the customer ends up paying it. As you'll recall, the statute requires us to appropriately balance the costs of implementation with the risk of a potential wildfire. Now, I certainly understand the risk of a potential wildfire is something you would be extraordinarily sensitive to given the things that have happened for the company. That's something we have to look at as well. But I guess I'm just trying to get some level of comfort as to what analysis we have in the testimony when you have the IE that basically says cost-benefit analysis is inadequate. I guess reasonable minds can differ as to what's in the testimony, but can you think of anything else that we ought to rely on as a commission to say, the customers are paying for this, this is adequate evidence to show that there has been an appropriate balance of cost to the reduction in wildfire risk? When we can't monetize, at least at this point in time, the reduction in wildfire risk, how do we perform that analysis?
Sure. Yeah, and we believed we were satisfying that requirement within code by balancing the two elements that we previously discussed. I'm not aware in the industry where there is this comprehensive balance between those two elements or a numerical model that has been presented. Even RSE that is outlined within the independent evaluators isn't applied to the plan in total. It's applied under our alternative analysis, and so that wouldn't have even if we had done the RSE, that would not have satisfied a balance of cost and risk in totality if we're defining that balance has to occur in totality. If we're saying, are there elements that we balance, so we now move past the total component, which is how whenever we develop the original 2020 plan or the 2023 plan or revise the 2023 plan, we thought we were balancing the two elements and that was appropriate for doing that. And where we see that there is a request to have a very quantitative analysis with specified models, it's typical for us to participate in workshops or sessions to agree to that model and the treatment against the plan so that we can be transparent on how the plan's developed and how those mitigations. And so that's, like we talked about, California, Oregon, we're actively participating there. Washington will start up, most likely Wyoming. And so we'll participate in every one of those jurisdictions to agree to the model. But again, it would be in a specific subset. I'm not aware that it has occurred in the industry to do it on the total plan between those two elements. That I'm not aware of one, nor is that what the RSE recommended by the IE.
No,
is doing.
and I appreciate what you're saying there. I just, to me, the question is, you would agree that the information is asymmetrical. You have more information on that as a company than the commission has unless it's provided to us by the division or the office. And I'm trying to see, how, even if it was done on a circuit basis, an evaluation of a reduction in risk based upon this cost and how you choose between these different costs. But
So maybe one item of note there is, we thought the annual cost and compliance reports were doing a piece of that. We
Okay.
supplied the deliverables in there, we supply the associated cost, we show the alignment against the filed plan, so that there is awareness to the work activity that we had recommended, the work activity conducted, and the associated cost with that. And so in the annual submissions, we thought that that was helping to address some of that analysis.
Yeah.
And if there was follow-up questions, we would have been happy to comply with that, but there were no requests for additional analysis off those annual cost and compliance reports. When we submitted the plan, or, January wasn't very long ago, and the IE recommended this enhancement for RSE, we're not disagreeing with that. We think that we should work through that. We just recommend a docket to work through that, so.
okay, and I appreciate that, and I think I'm sorry that I ended up asking so many questions. When I started down the road, I thought it would be about 5 minutes, and it turned out to be a little longer. But I have no further questions, and we very much appreciate your patience in responding to the questions of all of the folks who asked you questions, and we'll excuse you, Mr. Jones. Thank you very much.
Thank you.
Appreciate it. Okay, it's 10 after 3. Do we, I don't know, this is going to create an incentive on the commission secretary to push me again for a replacement of our audio-visual system in the conference room. We can take a break right now, or we can start with another witness. I would still like to get through the Rocky Mountain Power witnesses today. I vote we take the break now, considering we're competing with alien interference here. So we'll take a 15-minute break. we've had a little bit of a discussion about the interference. I know this is like asking you to cut off an appendage, but it may be helpful if you put your cell phone on airplane mode. We think that it's a bandwidth issue that's causing this. So if you don't absolutely need to have your cell phone where you can check messages, if you could put it on airplane mode, we'll hopefully be out of here in, I hope, in a little over an hour. Okay. All right, Mr. Saban, are you conducting the next round?
I'm up, yes.
Thank you. Good to have you with us again.
Glad to be here.
Okay, looks like we're going to call Mr. Barrett.
Yes, the company calls Alan Barrett to the stand.
Mr. Barrett, welcome. Would you raise your right arm to the square? You solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. You may be seated. Mr. Saban.
Thank you. Mr. Barrett, would you please provide your full name and your title with the company?
My name is Alan Barrett. I'm the Vice President of Power Delivery Operations for this.
Would you just make sure your mic is turned on?
How about now?
Is the light on?
Little
Yeah,
light
maybe
bit.
move it a little closer. I don't think you're getting picked up.
How about now? Is that any better?
That's better.
I feel amplified.
I can hear it out here. Although maybe the court reporter can't.
Can you hear it okay? Okay, well, that's the key thing, so.
Use your outside voice, Mr.
Fair
Barrett.
enough.
All right.
Okay, sorry, state your name and your title with the company.
Alan Barrett. I'm the Vice President of Power Delivery Operations for Pacific Corp.
Okay, and in that capacity, what do your responsibilities encompass?
In that capacity, I oversee a number of the support groups within power delivery or operations, such as finance, emergency management, meteorology, vegetation management, and a number of other support groups.
Okay, great. Mr. Barrett, I show that you have submitted in this proceeding Phase 1 direct testimony, which has already been admitted into the record with exhibits, and then and some Phase 1 rebuttal that's also been admitted into the record, and then Phase 3 rebuttal as part of this Phase 3 proceeding. Is that correct?
That is correct.
Do you have any corrections to your Phase 3 rebuttal that has not yet been admitted into the record?
I do not.
Okay. And if we were to ask you the same questions that are posed in that rebuttal testimony, would your answers be the same?
They would.
Mr. Chair, I move for the admission of Mr. Barrett's Phase 3 rebuttal testimony.
Thank you. Is there any objection to the admission of Mr. Barrett's Phase 3 rebuttal testimony? Seeing none, it is admitted.
Mr. Barrett, have you prepared a summary of your wildfire mitigation testimony in both Phase 1 and Phase 3 to the extent it's applicable to what we're talking about here?
I have.
Okay, would you please share that with us now?
Yes, thank you. Good afternoon, Chair Finn, Commissioner Harvey. As noted, I have submitted direct testimony and rebuttal testimony regarding wildfire mitigation costs in Phase 1, and I also submitted rebuttal testimony regarding wildfire mitigation costs in Phase 3 of this proceeding. In my testimony, I review the company's request for recovery of costs associated with the company's approved 2020 Wildland Fire Mitigation Plan, including deferred costs, and discuss why the costs for certain company wildfire mitigation activities approved in that plan exceeded the cost estimates in the 2020 plan. In my testimony, I also discuss costs the company requests to recover in connection with its proposed 2023 Wildland Fire Protection Plan. As to both of these categories of cost, I provided information showing that the costs sought to be recovered by the company are reasonable, incremental, and in the public interest. As I noted in my testimony, the company has always had to address fire risk. However, due to various factors such as severe drought, climate change, and a growing population, the risk and frequency of wildfires in the company's service territories, including Utah, has significantly increased. Further, when wildfires do occur, they can be more severe, even catastrophic, if near population centers. Due to the increasing risk and severity of wildfire, state governments and utilities throughout the United States, and particularly particularly those in the western U.S., have placed a greater focus on wildfire mitigation. In Utah, this increased focus led to the passage of Wildland Fire Planning and Cost Recovery Act of 2020. As others have explained, that act requires utilities to prepare and submit for commission approval every 3 years a plan for wildfire mitigation that satisfies the various requirements of the act. The act requires the commission to authorize the recovery and rates of prudently incurred investments and expenditures to implement an approved plan. It requires authorization of the deferral and collection of incremental revenue requirement for capital investments and expenses to implement an approved wildland fire protection plan, where these costs were not incurred in base rates. With regard to the company's 2020 plan costs, the company prepared that initial plan in response to the act and submitted it to the commission for approval on June 1st, 2020, just under 1 month after the act went into effect. To prepare that plan, the company performed certain modeling and analysis to identify wildfire risk and propose an initial mitigation efforts to start addressing those risks. Through that process, the company developed cost estimates for those initial mitigation efforts that it included in the 2020 plan. In my testimony, I discussed the deferred and incremental costs associated with the 2020 plan. I want to emphasize the wildfire mitigation costs, like other utility costs, cannot be precisely determined in advance when a plan is submitted to the commission, and the company takes its mitigation obligation as well as its obligation to manage costs seriously. With regard to the cost categories where actual costs exceeded the cost estimates in the 2020 plan, or where the company incurred costs for additional work, as I discuss in detail in my testimony, these increases were due to several factors, including the following: the unpredictable and changing nature of wildfire risks and mitigation efforts needed to address those risks, the inflationary factors, supply shortages in both materials and labor, and other market uncertainties during and following the COVID-19 pandemic, and finally, the modeling improvements and other data that caused the company to revise its risk assessments and expand or change the mitigation activities. As a result of these changes, the company incurred and is seeking to recover $21 million in incremental costs for 2021, 22, and 23, associated with the implementation of the 2020 plan. In my testimony, I address only the O&M costs. Ms. Shelley McCoy addresses the capital expenditure portion of those costs. Specifically, I first show that certain components of the company's vegetation management program were increased or changed incrementally from the baseline, causing the company to incur incremental costs. That program includes the inspections of all lines in the FHCAs to identify and remove high-risk trees at the earliest stage possible. After the 2020 plan was approved, the company increased the minimum clearance distances for distribution cycle work completed in the FHCA, performed annual pole clearing, and applied herbicides and soil sterilants to prevent regrowth. The costs associated with these efforts reflect an incremental spend needed to accomplish new tasks, and hence the costs for this work were incremental. Second, after the 2020 plan was approved, the company made condition corrections, weather station network expansion, and changes to its patrolling activities. Those activities were necessary but resulted in an increase in costs. Those costs include additional patrolling during high fire risk periods to inspect the system for damaged or worn equipment that can be corrected before an issue or potential ignition occurs. Those costs also include emergency management engagement with communities and wildfire risk modeling and forecasting software. Third, the company included labor costs in its deferred amount associated with wildfire mitigation efforts. As I demonstrated in my testimony, those costs were not already included in base rates. The company's testimony explains the necessity of these activities, and no party has provided evidence demonstrating otherwise. The office and DPU expressed concern that the company's labor costs may not be entirely incremental of the amounts included in base rates, but that concern is refuted by the evidence, including evidence I specifically provide. The company uses both internal employees and contractor labor to perform incremental wildfire work due to fluctuating work volumes and the need to respond immediately to high-risk situations. As shown in my Phase 1 rebuttal testimony and my Phase 3 rebuttal testimony, by reviewing the company's activities, which are tracked on an activity-specific basis, it is clear that the labor costs included in the deferred amount are incremental to what was included in base rates. For instance, in some cases, the company had to pay employees for overtime wages not included in base rate labor costs. In addition, both employees and third parties had to be paid to address an increase in work scope, which caused costs to exceed routine operational and maintenance costs included in base rates. I provided in my testimony tables A and B, which showed these costs, both wildfire and non-wildfire, so they could be seen in totality. Similarly, I strongly disagree with the DPU's claim that the Commission should deny entirely the deferred amount the company seeks to recover because, according to them, the deferral amounts exceed what the Commission approved in the 2020 plan, even when accounting for changes in the Consumer Price Index. This claim is flawed for two reasons. First, the 2020 plan is not a cost cap under the Act. As I noted previously, the Act specifically contemplates the recovery of prudently incurred incremental costs. Incremental costs are, by their very nature, over and above the amount approved in the Wildland Fire Mitigation Plan. And that is what occurred here. The 2020 plan provides cost estimates, but the actual costs exceeded those estimates due to various factors that are not disputed. The company has demonstrated the prudence of the activities leading to those costs, and as such, the company should be able to recover those incremental costs under the Act. Second, the DPU's CPI analysis is incomplete. The nature of wildfire mitigation is that one cannot know in advance how the program will evolve, particularly taking into account the changes in wildfire risk and emerging best practices. While Mr. Lee attempts to apply a consumer price index adjustment to show that the company's increased costs cannot just be explained by price increases, his analysis does not use actual costs incurred by the company to complete the work, nor does he account for any of the additional mitigation work that was not included in the 2020 plan initially. He provides no basis to believe that this additional work could be completed at the same cost as approved in the 2020 plan, even at a CPI-adjusted rate. Further, Mr. Lee's analysis does not demonstrate that any of the additional work conducted by the company was not necessary or prudent. Also, as I address in my Phase 3 rebuttal testimony, Mr. Lee incorrectly assumes that the vegetation management work under the company's normal operations was included in the wildfire mitigation plan costs. That is not correct. Now, switching to the costs associated with the 2023 plan. My testimony supports the cost amounts included in that plan. Since 2020, the company has engaged in extensive work to improve its risk modeling, better identify high-risk ignition areas, and improve its mitigation efforts and mitigation planning. The company's efforts are in line with industry best practices and include input and feedback from the Utah Division of Forestry, Fire, and State Lands. The cost amounts included in the 2023 plan reflect that significant work. As explained in my Phase 3 rebuttal testimony, I strongly disagree with the OCS's position conveyed by Mr. Vostog that the Commission should not approve the company's 2023 plan and instead only allow the company to recover costs at the levels in the 2020 plan with a 3-year average for setting wildfire O&M costs. The 2020 plan was an initial plan to address a first round of mitigation efforts identified by the company. The 2023 plan is much more comprehensive and addresses a broader set of fire risks through a much more extensive set of fire mitigation efforts. It makes no logical sense to cap mitigation costs for the 2023 plan at amounts that were applicable to the 2020 plan, which was focused on a smaller set of mitigation efforts and a narrower set of identified fire risks. Nor would it make any sense to use 2020 cost figures when the OCS, DPU, and others in this matter acknowledge that materials and labor costs have increased substantially since 2020. Finally, in my Phase 3 rebuttal testimony, I explained that Mr. Vostog is in error when he asserts that the IE agrees with the OCS position that the company has failed to identify costs that are incremental in its 2023 plan. As I explained, the IE incorrectly notes that the company has included total cost categories in the plan, and those totals are in fact costs incremental to normal company operations. As such, none of the amounts identified in the 2023 plan are duplicative of costs for other company programs outside the wildfire mitigation program. For the reasons explained in my testimony, the Commission should approve cost recovery of the amounts the company has incurred in implementing the 2020 plan and will incur implementing the 2023 plan. Those costs are prudent to address an undisputed risk, and the information provided by the company complies with what the company is required to provide under the Act. This concludes my summary.
Thank you, Mr. Barrett. Mr. Barrett is available for questioning.
Thank you, Mr. Barrett, for your summary. We appreciate that, and thank you, Mr. Saban. We'll see if there are any questions for the division.
No questions from the division, thank you.
Okay, Mr. Snar, I think you'd already indicated no questions. Have you changed your mind?
Almost, but I'll refrain from that. I'll have
Okay,
no questions.
all right, thank you. Any,
No questions from FFSL.
all right, Mr. Russell,
No questions. Thank you.
Ms. Hayes?
No questions.
Okay, perhaps it's too much to hope that Commissioner Harvey has no questions, but we're going to see what he has. There's some questions. I'm sure he'll have some.
It is too much to hope.
Yeah, I knew that, I knew that.
Just a few questions responding to your summary. You started out by saying that the costs that the company is requesting to recover were reasonable and prudent. Do you remember that?
I do.
Can you explain to me how you would expect the commission to judge the reasonableness and prudence without some type of a cost-benefit analysis?
Sure, a couple things there in response. First, I would judge the reasonableness and the prudency based on the work that was done to go into the plan. And what I mean by that is the risk modeling that was done to identify areas of highest risk. And so it wasn't the same mitigation work applied everywhere across our service territory. We prudently decided to evaluate that risk and determine which areas are of the highest risk that have all the ingredients for that catastrophic wildfire. And then we applied mitigation efforts that are in line with industry practices. You see that in our 2020 plan. You see it more robustly in the 2023 plan. You see it backed up by the IE's findings as far as our effort in identifying that risk and applying mitigation plans towards that top 15% risk that Mr. Jones was speaking of. Again, not applying these mitigation plans everywhere, not a blanket approach, but a scientific, numerical, risk-driven, where is that risk in our service territory? Therefore, prudent that that is where we're focusing these mitigation costs. Choosing the lesser costing mitigation, such as the operational practices, vegetation management being one of them, for the remainder of the system, that 85%, saying where fire risk can be everywhere across our service territory. So we prudently decide not to rebuild lines everywhere, but choose those operating practices to help mitigate fire risk in that other 85%. So that's that balance. The 15% top risk, the 85% operational practices for the remainder, line rebuild going to the riskiest areas.
So the company is asking the commission to, and I don't mean this pejoratively, but to accept on faith, i.e. based on expert opinion within the company, that the 15% is the amount that is the amount where a significant mitigation is reasonable.
Right, by looking at that risk modeling that Mr. Jones was describing, and you see the risk scores of all the inputs that he was describing goes into that risk modeling. And if you look at the distribution of those risk scores across our service territory and looking where that top 15%, that binning of those risk scores and saying that's appropriate to go after. I would say you don't just have to take our word for that. I would say that's what the IE found as well, where they said the risk modeling that we did was appropriate and in line with industry that identified that top 15%. That carving out that top 15 as risk and a higher risk and appropriate risk to go after with mitigation was appropriate.
Okay. But you agree the commission has not been presented with a cost-benefit analysis in this record?
I would agree in this record, a numerical cost-benefit analysis hasn't been provided. I would go further to state that it was not a requirement in the statute, understanding that is what people are looking for. And I think as you heard through Mr. Jones, we understand that, and that's an evolution of where we're taking it. To do that is no simple task. And so we can't oversimplify what that means of like, well, why didn't we just not provide that in the plan? Why isn't that just detailed out? Someone with your background understands all the data, right, that goes into that cost-benefit analysis. What we would struggle with and need collaboration and direction on is that valuing that risk, which means how much do you assign to a structure damaged? How much do you assign to a life? We could have come up with numbers and just put numbers out there for people to debate, and maybe that would have made this process go easier if we would have done that. But I doubt there would have been alignment on how we were valuing that risk. But that at least would have shown a model that then we could have been debating what value was put towards it. Instead, we went with the unitless risk score that Mr. Jones was talking about, which we're saying in these areas, it has the catastrophic fire risk. How I value that catastrophic fire, what dollar amount to put to it, is the evolution. That is no simple task to get to.
Would you agree that there's a second step of also the probability that needs to be added to that evaluation?
I agree that risk modeling traditionally has probability and the impact, right? Those two matrices, right? So probability, when will this risk occur? What's the probability? So does that have a place in that modeling? It does. However, a first step when you look at risk modeling for the utility is you identify the areas with all the inputs Mr. Jones talked about that say, yeah, but if a catastrophic fire, it started here for any reason, does it have the ingredients to create that impact to structures and people? And then the probability of, all right, I'm operating in that area, right? And that's the probability of fault of the equipment. First, I just want to identify those areas that are of highest risk regardless of the cause. And then I say, but I'm operating in that area, so therefore I could be the cause. And so therefore that part of the model comes in as well.
And what if the sense is that the probability of, it's a high consequence area, tens of millions, possibly hundreds of millions of dollars of damage, but the probability is effectively zero of something starting? It sounds like the approach the company's taking isn't accounting for that low probability.
I don't believe that's 100% correct. I believe the probability is in there, and what we need to find is the right way to weight it in that formula of how is that driving that risk modeling. Probability of equipment failure or probability of ignition or probability of vegetation management, I would say is in there because that is what goes into that composite score, which is an area that is traversing rural area with a lot of trees, goes up in the risk modeling. It has a higher risk score. So I would say that the probability, it's the trees that have the probability of causing an issue with utility lines. So that probability is in there.
Okay, thanks for that. I was intrigued with your discussion when you talked about what an approved plan means from the company's perspective. You talked about not being restricted to the amounts approved in the plan. That caught my attention. So I guess what I'd like is a statement to say, what does PacifiCorp view an approval of a plan to mean with respect to budgets?
I don't want to object. I do want him to answer that question, but I want it to be clear that he's answering it not from a legal perspective. And I'm sure that's how you intended it, but.
Well, I just want to know how PacifiCorp is going to actually treat those budgets.
I think Mr. Saban makes a good point, and I don't think that's what Commissioner Harvey's asking, but I think that the caution to the witnesses, give your understanding, but we're not expecting that for the legal conclusion.
Sure, thank you. When we develop these plans, it's putting our best foot forward. right? Where we try to determine what is that risk, what are the mitigation, you add up all these programs, and you say, this is what we believe that the cost of those mitigation plans are gonna be. However, what we've also seen and learned is that the wildfire risk is continuing to evolve. My best laid plans in 2020 doesn't work in 2023. The wildfire, the risk is growing. The programs need to evolve. So how do I view those dollars put forward? It's our best guess at that time. It's our best estimate. It's our target. Is it a cap? No, we do not view it as a cap. Is it a signal of where we think the costs are going and what we think they're going to be at that time we wrote the plan? Yes.
Assuming at some point in the future, some plan gets approved, if the commission included language that said, these are a cap, come in if you think it's gonna cost more and ask for a revision, would Pacificor find that troubling, or?
Of course, we would follow whatever administrative rule comes out. I think the downside of that is the amount of time it takes to review these plans, what's going on and submitting it. So the annual cost and compliance report is kind of trying at that, where we're saying, we file that and say, here's what's actually going on, here's where the costs have gone over, here's the reason why, here's the activity. So I would say that is a step in that direction. Now, whether that was formalized in an additional rulemaking, or obviously we would follow it.
But Pacificor then would view that report as the primary avenue or venue where parties or the commission could raise concerns about the level of spending?
That would be one avenue, right, where we are describing what our actual costs are relative to that last plan approved.
And that would be after the fact, right?
After the fact of.
You've already spent it by the time you report it.
That is correct, because that's showing dollars spent to date, correct.
Okay. You're aware, and you mentioned in your summary, that there's been some disagreement among the parties and in the testimony about what costs are actually incremental. I'm curious if Pacificor has thought about what type of an accounting structure might be put in place to be able to prove to the parties that everything that's in base rates has been spent before something is claimed to be incremental.
So I would point to Ms. McCoy for the kind of the accounting treatment of that. From an operations point of view, though, as far as how I actually account for the work, meaning work orders and assign it to resources and achieve it, I would say I have that accounting in place, which is to create specific work orders that is already assigned of whether or not it's part of an incremental wildfire program or whether it's part of an underlying program, a maintenance program that has been in place, say, for a number of years or a decade or more, right? So that accounting within the actual operating group of how that is done. How to express that and bring that up in the accounting-wise, I'll let Ms. McCoy speak to that.
Okay, we'll follow up with her on that. These are probably McCoy questions then, but in your summary, you mentioned 2020, 21, and I think you then skipped to 2023 costs, talking about deferrals. And I don't know if I misheard you, but is there anything special about 2022?
No, sorry if I misspoke. It's 2021, 2022, and 2023.
Okay, and it might have been me mishearing as well. Okay. So then going back to that word incremental, in your summary, and this kind of goes back to the budget question, but it sounded to me like your position was it was incremental if it exceeded what was in the plan. Did I get that right?
No, incremental to the underlying activity that existed before the plan to go after wildfire mitigation, not incremental to the wildfire mitigation plan.
Okay. And so anything about over budget, I could rely on the previous question I asked you to understand your position there.
That's correct.
Okay. So the 2023 plan is currently not approved, correct?
That is my understanding.
Okay. And so in terms of the operation of the statute and the commission's obligations, do you agree it changes a bit as determining, hinging on whether or not that plan is approved or not?
Sorry, what changes whether or not
Well,
it's
sorry,
approved?
it was a bad phrasing. The commission has, under the statute, an obligation to let costs be recovered if certain things are met. One is the plan's approved, and two is the commission does that balancing that we've been talking about extensively today. So if the plan's not approved, would you agree that the commission's approach has to change a bit in terms of how it evaluates that spending?
So I don't claim to understand all the ways in which you have available to you. So if the plan is approved, obviously there's a path for the recovery. I would understand that there's ways that you could approve recovery of the cost outside of an approved plan as well, but I don't claim to understand all the ways you have available to you.
Okay. All right, that's all my questions. Thank you.
Mr. Barrett, thank you for your patience, and I just have just a couple of follow-up questions. You said, I believe, that the company desires to put its best foot forward. Is that kind of a excerpt from your summary, your testimony?
When we're developing the wildfire mitigation plans, that
correct.
we're trying to put our best estimate forward.
Right. So that would include trying to use your resources in the best manner according to your analysis and judgment, correct?
That is correct. With our own lessons learned, experiences, the own data we're collecting, I would also note, and with collaboration with the industry, as we learn what others are doing that maybe we should be incorporating into our wildfire mitigation plan. I feel it'd be a mistake to believe I couldn't incorporate those mitigation efforts until 2 more years goes by and I create a new plan.
Okay, I appreciate that. I think this is an obvious statement of law. I'm not asking for a legal conclusion, but the commission has to determine whether the investments of the company were prudent. And in doing so, the goal is to establish just and reasonable rates. That's for both the company and for the ratepayers, correct?
That would be my understanding.
Okay, and that's our obligation. It's sometimes perhaps a difficult balancing test, but that's the underlying principle. We're looking out for ratepayers, but we're also trying to be just and reasonable with respect to the company as well.
And we appreciate that.
Okay, now I want to ask just 2 questions about the 85% of other areas. Your wildfire mitigation plan takes into account the top 15% of in the fire high consequence areas of a risk factor as far as the 15 most percent risky areas for wildfires. That maybe that was inartfully said, but that's basically it, correct?
That's correct. That's looking at our service territory and saying it's that top 15% risk of catastrophic wildfire is what created that FHCA area.
Okay, I just want to ask then a question about areas of interest 1 and area of interest 2. So my understanding is area of interest 1 are those in the 65 to 85% risk factor, and area of interest 2 are in the 45 to 65% risk factor. Is that correct?
That is my understanding, and why we felt that was important to show is to further a conversation that risk is not binary. There is not only wildfire risk in that FHCA, that top 15%, and no wildfire risk everywhere else. So we were showing the layers of risk as you move away from the FHCA. What is that next 20% layer of risk, area of interest 1? What is the next 20% area of interest 2?
Okay.
Just to show the gradient.
Fair enough. Are those areas of interest 1 and 2, are they on, in some cases, inside of an FHCA, or are they always outside of an FHCA?
To the best of my knowledge, they are outside. It's a different area. They do not overlap.
Okay, they do not overlap. Okay, that's what I wanted to understand. And let me just make sure I understand the company's plans, because there was some question in the testimony. I'm trying to understand the company's intention with respect to wildfire mitigation. You're not planning on anything other than the regular cycle of vegetation management and the regular cycle of inspections in the area of interest 1 and 2 at present. Is that correct?
No, let me clarify. So inside the FHCA, you see targeted programs, very straightforward, line rebuilding, right? Outside of FHCA, it becomes a conversation of what mitigation practices should be applied. Some of them are applied everywhere across that remaining 85%, such as our ability to do public safety power shutoffs.
Sure.
We're ready to do that anywhere.
Yeah.
Our weather station network is across the entire service territory, even though it's outside of that FHCA. Vegetation management, our inspection program, we look at those too and go, well, what should be different about those programs in that remaining 85%? And so we are looking at those programs as well to determine, should I do more frequent vegetation management inspection, let's say, on circuits that are outside of the FHCA? As of yet, that program has not evolved there, but I just wanted to provide that context of that's a thought process.
Right? No, and I think that's very helpful, and I should have recognized that and included those other factors as well with respect to the PSPS type of situations and the meteorological issues as well. But you don't have plans to do line rebuilds in those. In the one case, it's area of interest 1, 1,394 miles, and area of interest 2, another 2,476 miles. Is that correct? You're going to focus your principal wildfire mitigation efforts in the top 15%.
That is correct. Line rebuilding is targeted to that FHCA. The only exception to that is the boundary conversation that you were having with Mr.
Right.
Jones about,
Yeah.
right, as you go in and out of it, how much do you rebuild? But there are no targeted line rebuild programs toward area of interest 1 or area of interest 2.
And I suppose the only exception to be that if you had some 50-year type event, you had something that blew down lines where you may need to do you may make a decision then to do a line rebuild, but that wouldn't be within the wildfire mitigation plan. Is that correct?
That's correct. And
Okay.
so, yeah, if an opportunity arises for us to rebuild, or we're looking, well, where should that wildfire mitigation standard, that rebuild standard of how to do construction apply? But outside of the wildfire mitigation plan.
Okay, that's what I wanted to make sure of. I have no further questions. Thank you very much. Appreciate it. Mr. Barrett, you may be excused. Thank you.
Thank you.
I'd like to see if you're all okay with Ms. McCoy. I guess the question of whether Ms. McCoy is willing to get her testimony finished tonight, and we're all okay with that?
We are.
Want to be considerate of, it's a long day, but she is coming forward, so I think the answer has been received.
The company calls Shelley McCoy as its next witness.
Thank you, Ms. McCoy. It's nice to see you again. Please raise your right arm to the square. Solemnly swear the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You may be seated. Mr. Saban.
Thank you. Ms. McCoy, would you please state your full name and your title with the company?
Yes, Shelley McCoy, Director of Revenue Requirement.
And Ms. McCoy, I show that in Phase 1, which you had a number of items of testimony that cross over with issues here in this wildfire mitigation portion of Phase 3. Those have been submitted into evidence and admitted. And then in addition to that, you have Phase 3 direct testimony in this proceeding and Phase 3 rebuttal testimony in this proceeding.
Correct.
With exhibits.
Correct.
And are those, are there any corrections or changes to those items of testimony that have not been admitted yet?
No.
If we ask you the same questions as and answers that are presented in that testimony, today, would they be the same?
Yes.
Mr. Chair, I move to admit into evidence the Phase 3 direct testimony and the Phase 3 rebuttal testimony of Ms. McCoy with the associated exhibits.
Okay, thank you, Mr. Saban. Motion to admit the direct and rebuttal testimony of Ms. McCoy with his exhibits that were filed with those. Is there any objection? Okay, they're admitted into evidence. Thank you.
Thank you. Ms. McCoy, do you have a summary of the testimony for this phase of this docket?
Yes, I do.
Would you please share that with us?
Yes. Good afternoon, Chair Finn, Commissioner Harvey. My testimony supports the inclusion of the costs of the company's 2023 Wildfire Mitigation Plan, or WMP, in the proposed 2025 test year revenue requirement in this general rate case. Company witness Mr. Josh Jones supports the 2025 test year costs of implementing the 2023 plan. These costs were updated in the company's Phase 3 rebuttal testimony with the acceptance of operations and maintenance, or O&M, adjustment proposed by OCS witness Mr. Paul Alvarez. This update reduces the company's request in this case by $3.5 million, bringing the requested increase to $328 million. This updates the requested Wildland Fire Mitigation Balancing Account, or WBA, base to $49.2 million. Included in this amount is the return on a rate base of $193.8 million. This rate base differs from the 2023 WMP capital expenditures for 2025 of $156.9 million. The $156.9 million represents capital spending, but not necessarily completed projects to be included in rate base. The difference between the two numbers is timing of spend versus completion. Additionally, the rate base is comprised of all completed capital projects on a 13-month average basis. In my direct Phase 1 rebuttal and Phase 3 rebuttal testimony, I provide support for recovery of the December 2023 balance in the WBA of $21 million. In docket number 23-035-27, the company requested recovery of the deferred balance in the WBA as of April 30th, 2023, as part of its annual cost and compliance report. In that docket, the Commission issued an order denying the company's request without prejudice on the basis that the company did not provide substantial evidence that the deferred costs were not already recovered through base rates. In this general rate case, both company witness Mr. Alan Barrett and I provide support explaining how PacifiCorp tracks WMP costs through the use of work orders and provides substantial evidence of the incremental nature of the costs recorded in the WBA, including multiple exhibits, work papers, and transaction-level detail of costs recorded in the WBA. OCS witness Mr. Bela Vestog recommends the Commission deny recovery of the $21 million WBA balance, continuing to maintain his position that the company has not provided evidence that the deferred costs are incremental to those in base rates. However, Mr. Vostog's analysis appears to focus primarily on the company's headcount and not on the dollars incurred or how the company has accomplished not only its WMP efforts, but also continued its other operations and maintenance activities. As described by Mr. Barrett, this work is accomplished through a combination of internal and contract labor. Focusing only on internal headcount narrowly focuses on only one data point and overlooks the total costs. Mr. Vostog requests a level of employee forecasting in rate cases that is just not feasible. He criticizes the company for not developing forecasts that are detailed enough that they can be compared to actuals. However, it is not reasonable to expect the company to prepare a forecast of labor at the position level for nearly 5,000 employees for inclusion in a rate case. This level of forecast, even if it could be prepared, could result in overly prescriptive parameters in the O&M activities performed by the company. It would not recognize the need for flexibility in addressing immediate or emerging issues. While the company has provided substantial data in support of its WBA balance, Mr. Vostog himself stated in the Phase 1 hearing that he is not sure what reporting or evidence the company could provide to satisfy him that the deferred costs are indeed incremental. Mr. Vostog appears to be creating an impossible standard that the company cannot meet. DPU witness Mr. Jonathan Lee also recommends the Commission deny recovery of the WBA balance based on the fact that the company spent amounts incremental to those included in base rates. However, this is the exact purpose of the WBA, to record incremental costs of implementing a WMP. Additionally, Mr. Lee seems to propose a new regulatory requirement where the company seek approval from the Commission before incurring costs above the amount in base rates. While I am not an expert in WMP efforts, Mr. Lee's recommendations do not provide the company the flexibility to determine the particular WMP activities it should undertake each year to mitigate the risk of wildfires. Rather, Mr. Lee would have the company spend within amounts set within base rates for each program category unless seeking approval from the Commission to deviate from these amounts. I recommend that the Commission find the company has provided ample support and evidence for the amounts recorded in its WBA and approve recovery of the $21 million balance over 1 year through Schedule 97. Finally, my Phase 3 direct testimony addressed concerns raised by the independent evaluator related to the company's recovery of transmission-related wildfire mitigation costs. In my testimony, I explained how a portion of these costs are recovered from PacifiCorp's third-party transmission customers and how the benefit of amounts recovered from transmission customers are passed back to Utah customers through their allocation of wheeling revenues. I believe this existing process adequately addresses the concerns raised by the independent evaluator on this issue. This concludes my summary. Thank you.
Thank you, Ms. McCoy. Ms. McCoy is available for questioning.
Thank you, Ms. McCoy, for your summary. We appreciate that. Ms. Schmidt, cross-examination.
Good afternoon. Good afternoon. The division has what it hopes will be just a few questions for you. Is it fair to say that in your rebuttal testimony at, for example, page 4, lines 79 through 83, you address the division's use of the word budget? And I'll give you a moment to get there.
Okay, excuse me, did you say page 4?
Page 4 of your rebuttal, lines 79 through 83, if I can read my scribble. Yes, so in describing the costs that are recorded in the balancing account, I'm clarifying that the comparison is to the amount in base rates. Now, I'm not terribly familiar with the WMP, but the amounts that are
are proposed for each year in those WMPs could vary. And they could vary from the amount that's set in base rates. And so I'm just trying to clarify that it's not necessarily a comparison to budget, but a comparison to what the company recovers through base rates.
And so is it your testimony that the spending plan in an approved WMP is not a budget to which the company has to adhere? If you know, and if this is within the scope of your testimony, and I hope it is.
Well, I think we heard Mr. Barrett speak that we do not view it as a cap, but again, when it comes to the balancing account itself, the comparison is to what is in base rates, not what is in the WMP each year.
Do you agree, whether or not you call the WMP a budget or not, and you do not, that there has to be some relationship between the numbers in the WMP and the actual numbers for which cost recovery is sought?
I believe that when it comes to the balancing account, the relationship is what was spent to implement the WMP versus what the company recovers in base rates.
Thank you. Just a couple more. Is it your opinion that the WMP must contain some sort of cost effectiveness information? Question mark.
I am not an expert on the WMP, so I cannot provide an opinion on the numbers in it or the purpose of it, beyond the fact that I understand it is a plan for mitigating wildfire risk.
Turning back to the general rate case portion of this, would you agree that the expenditures for wildlife mitigation plan and related costs that are included in recovery through the general rate case must be prudent?
I agree that similar to any other costs that we've included in our 25 test year, that the commission will make a determination of that if that is the appropriate amount for setting a revenue requirement.
Thank you. Those are all my questions.
Thank you, Ms. Schmidt. Mr. Snar, anything?
No.
Okay, all right, thank you.
No questions.
Okay, Mr. Russell,
No questions, thank you.
Ms. Hayes?
No questions.
Okay, do you have any redirect?
Mr. Dallas has got a couple of questions.
Mr. Dallas, please.
Yeah, I just want to clarify the record. Well, not clarify the record, just clarify the mechanics behind the wildfire balancing account. So in the wildfire balancing account, what two numbers are being compared?
So there's actually a few numbers that get compared, and just to make this a little easier, I'm going to flip to my exhibit from Direct of Exhibit RMP SEM 9. So when costs get recorded into the WBA, there is a comparison of what was the actual capital projects that went into service. So the rate base element, and how did that compare with what was approved in rates? And looking at my exhibit, one can see that for the first, we'll say roughly year and a half or so, maybe not quite, but the rate base amount the actual rate base amount was less than what was improved in rates, and so there is a credit or a reduction that's getting recorded in that balancing account to reflect that. And then there is the comparison of the expense, or primarily what we're talking about is operations and maintenance. And then that comparison is also done, you know, the actual spend versus what was approved in rates. And again, looking at my exhibit, there are some months where it's a credit or a reduction, and other months where it's an addition. And then there's interest recorded on that balance as well.
And Ms. McCoy, to summarize, would you say the comparison is between what is in base rates and what the company actually incurred?
Yes.
And the comparison is not what a particular year of a WMP would forecast versus what was.
Correct. So, for instance, the rates that are in place now, of course, were set effective January of '21. Again, I'm not an expert, but it is conceivable that the amounts that were projected in the 2020 WMP, the amounts for '22 and would be different than the amounts for '21. Like, I wouldn't necessarily expect them to be the same year to year.
All right, thank you. No further questions.
Yes.
Okay, thank you very much. Let's turn to Commissioner Harvey.
Thank you. I've got a general question that's actually on behalf of Commissioner Clark.
Okay.
But obviously, we're all interested in it. But he asked me to ask it for him. We're trying to make sure that we understand what is included in the application for the 2025 test year with respect to all of the different years of both the approved and the unapproved wildfire mitigation plan. So what is being asked to go into the rates that will be set with this docket versus what is being deferred? And particularly, it seemed that 2024 we were curious about, but if you could give us a general overview of that.
Sure. So I'll speak to the capital component first. The WMP, when it reflects capital, again, that is spend and not necessarily completed projects that are serving customers. So until the project is complete and in service, it would not be included in rate base, and the return on that would not be included in either the balancing account or in rates. So when we discuss the 2024 spend, as those projects are completed, if they're let's say if they're completed in 2024, right? The return on those projects for 24, that would be recorded in the balancing account. However, in the rate case, we have included all projects that are projected to be in service through the end of the 2025 test year or December 31st, 2025. So a project included in 24 is now included in rate base in the 25 test year, but only on a prospective basis.
Okay.
And then for the O&M component, that resets every year. So the balancing account includes incremental differences, both positive and negative, compared to what is in rates for 21 through 23. The 24 O&M is not anywhere in this rate case. It would be, the incremental differences would go to the balancing account and be brought forward in a future proceeding. And then for this rate case, we are setting a new baseline amount that would be used for determining the comparison for the future amounts to be recorded in the balancing account. Does that answer all of it?
I think so, but let me
Okay.
check with my.
Okay.
All right. Thank you very much for that.
Yes.
All right, get to the right point here. So I want to explore just a little bit more about the discussion you had with your council about base rates and incremental. It seems to me that there's actually three things that need to be considered, and I want to get your understanding whether you agree or not. And the basis for this question is that if I'm thinking about the whole chart of accounts that we often refer to in regulatory stuff, there would be a number of accounts that in my mind I would think are part of the general operations of the company, but which also that same account number would show up in the wildfire balancing account. So an example of vegetation management, there's some amount that is just what you're doing on this 3-year cycle. The company's doing, not you,
Sure.
obviously.
Yeah.
I hope you're not out trimming trees.
No, I prune the roses in my own yard.
Indeed, got you there. Okay. But there would also be, those same account numbers would have entries in the WBA as well, correct? Because they do vegetation management.
Right, and so this is where we get to the work orders that Mr. Barrett talked about. There's different work orders that are used for wildfire mitigation activities versus the other O&M activities. So what we often refer to as program vegetation management
Okay.
versus wildfire-related vegetation management, right? So using those work orders to track those two different categories of vegetation management, we would be able to isolate the wildfire mitigation component of those costs to be able to then compare the overall wildfire mitigation O&M to what's in rates to determine the amount that gets recorded to the balancing account.
Okay, and so my understanding based on your answers with your council was that they can take that work order for a wildfire type expense and compare it to what was in base rates for the wildfire plan. And if it was greater than that for a given month, then it would be one entry, and if it was less, it would be the negative of that entry.
Correct.
But that doesn't address whether the program expenses for the same chart of account, whether all of that was spent or not, correct?
So, no, it wouldn't, but I don't have it in front of me, but in Mr. Barrett's direct testimony, there's Table 7, which shows the overall operations and maintenance beginning with 2019. And it shows that it overall increases every year. And I will point out that prior to 2020, we didn't have wildfire mitigation spend. And then I believe it's in his rebuttal, he has Table A, which breaks out the various categories of operations and maintenance separate from wildfire, and then also includes wildfire. And on that table, and I believe that one starts with 2020, you can also see that every year the overall operations and maintenance accounts are increasing.
Okay. But I'm assuming, based on your experience in this docket, that you would agree that some of the other parties aren't convinced by that presentation, by dint of the adjustments they're recommending?
I'm honestly not sure what would satisfy them. I mean,
Well, right, I'm not asking you if,
Yeah.
I'm just saying you're aware that they're not satisfied, is all I'm
yes,
saying.
yes.
Okay. So my question, and I previewed it with the earlier witness, but would Pacificor be open to developing an accounting mechanism that simply shows there was this much in base rates for these activities, and we have spent that much before they consider the other?
Absolutely. If there is some type of recording or tracking of costs that would facilitate, the review and recovery of these costs, we would absolutely be supportive of that.
Okay, I'm assuming you're aware that we have a natural gas distribution utility in Utah, currently called Enbridge.
Yes, yes, I'm aware of
Goes
it.
through a lot of different names. They have something that we refer to as the infrastructure tracker. Have you heard of that at all?
I have not.
Okay, all right.
It sounds very capital focused, but I could be wrong, just because
Well,
infrastructure is usually capital related.
Okay. So I guess I can say, would you accept that in general, in their rate cases, they get an amount they can spend for replacing certain types of infrastructure, and that they have to go through and prove that that has happened each year? And then typically the first year after the rate case, they have to prove they spent a certain amount before they can allow anything to go into that tracker.
Okay.
So conceptually, do you think that Pacificor could do something similar to where they could prove certain amounts had been spent before they claimed other amounts?
Yeah.
All right. So I guess just encourage you to work with the the other parties to try and set something like that up. All right. I think that's all of my questions. Thank you.
Ms. McCoy, I think these are four of the most wonderful words you can hear at this time of the day. I have no questions. You may be excused. Thank you so much for your various appearances during this lengthy proceeding that's gone on for a couple of months.
You're
Thank
quite
you.
welcome.
Appreciate it. Okay, as Ms. McCoy leaves the stand, I just want to coordinate with council about tomorrow. So we still have 7 witnesses to hear from. My proposal is we do Mr. Lee tomorrow. It's anticipated that, I suspect most of this cross-examination would come from Rocky Mount Power. It's anticipated there'll be 30 minutes. And then I don't see any cross-examination anticipated for 4 of the other witnesses. So I'm hoping that will proceed with some dispatch. And then I see 20 minutes for Mr. Alvarez and Mr. Stevens each. So are we all okay on proceeding with all 7 witnesses tomorrow, and that we'll adjourn this evening?
That's fine with us. I would love to have, given that some of the order may be changing, I want to make sure we know the order for tomorrow.
I'm anticipating we'll start with Mr. Lee, and then we'll go down the order as it was originally provided. Mr. Vastog, Alvarez, Stevens, Higgins, Mitchell, and Mr. Melton bringing up the end. Is that okay with everybody?
Could we go with Mr. Stevens before Mr. Alvarez?
Sure. Is there any objection to that? I should say sure until I see if there's an objection. Any objection to that? Okay, we'll do that.
Thank you.
In fact, I have a scribble here that you've asked that before, and I just neglected to catch it. I have one other thing that's not substantive, but has it seemed exceptionally warm in here today to you?
Yes.
Yes.
I mean, it's I think it's been brutal. So I'm going to do what I can to see if we can moderate the temperature and see if we can get some air conditioning pumped into this room tomorrow. Is there anything else that needs to come up before the commission before we adjourn for the evening? Well, yeah, you can also, the gentlemen could remove their suit coats or, well, the women who have on snazzy blazers or coats can also take those off. But I think we'll try to get it cooler. That will be because I won't take my jacket off. I'll just be miserable. And so I'd like to see if we can get it cooler. Okay, anything else we need to cover? Okay, we will stand adjourned until 9 a.m. tomorrow morning. Thank you, everybody, for your attendance and participation today.
Thank you.